Python number one. impugn order is without faith 170. One 72, 173. Order dated Milord 3/1, 1/3/2025. That is 132. 132. 132. That is order dated 1/3/2022. Ten of the 20. What is it? No, like it. However, the Alani district judge wrongly passed the impugn order by wrongly holding that the order dated 1/3/2025 passed in miscellaneous application number. It's miscellaneous application number 52 public 52. It's a 52. Yeah, 50 miscellaneous application 50. Okay, 52. Filed in the Procedural Civil Appeal 10 of the 2024. In civil appeal number 10 2024 passed by the Alani Civil Judge Senior Division is a decree was a decree from where appeal lies start. And by passing the said impugn order, impugn judgment and order dated 18/8/2025 in Basar Civil Appeal number 04/2025, the Alani District Judge come in charge additional district judge has acted in exercise of its jurisdiction illegally or with material irregularity. Stop. Issue notice. Return to the respondent, returnable by 4 weeks. Stop. Call for the trial court record. Stop. The petitioner shall take steps for notice upon the respondent by a registered post with AD as well as by usual process within a week from today. List is matter after 4 weeks. Stay of your matter. Hard, huh? Same. Mr. D. Boji. Sorry, M. Boji, Planning Council for the applicants. Para. By this application, the petitioner prays for stay of the impugned judgment and order dated 18/8/2025, passed by the Basar Civil, passed by the District Judge Alo come in charge Additional District Judge West John Basar, passed in Basar Civil Appeal number 04/2025. Day of what? Which one? 18/8/2025. 18/8. Okay. Issue notice. Issue notice returnable by 4 weeks. The applicant shall take steps upon the respondent. Take steps for service of notice upon the respondent by a registered post with AD as well as by usual process within a week from today. List is matter after 4 weeks. Para. In the meantime, till the returnable date, the operation of the judgment, impugned judgment and order dated 18/8/2025, passed in Basar Civil Appeal number 4/2025 by the District Judge Alo come in charge Additional District Judge West John Basar shall remain stayed. Okay, here say till the next returnable date. I think there is no prayer for stay of the Keba decision. There is no prayer. I haven't seen. This is only the operation of the impugned judgment and order passed in the condonation petition only. My lord, the appeal is in the appeal also there is no prayer. I have seen. For the legal. There is no prayer for that. There is no prayer for stay of the order passed by the appellate authority. Report.
Pattern number 2.
Yes. Yes.
Lordship, Petitioner, before your lordship is challenging the appeal for Pardon number 2. And Excel versus what happened, Lordship? There was a place level cover. Place level cover was passed the decision on 16/7/2005. And against that place level cover, the petitioner and the respondent, they filed affidavit. So, Lordship, affidavit. Both have filed their own appeal against the place level cover. Now, the affiliate authority, they are taking the appeal in respect of the file by the respondent only, but no someone, nothing has been taken up in my,
Why both have filed appeal? Both are aggrieved.
both are active.
Okay.
Both have their own ground.
Okay.
So definitely it is not prevented anyone to file appeal. The person who agreed the cover decision, definitely they will file appeal. But my case, since the both have filed,
Who filed first?
it was me who filed intention to appeal on same day, date of Kavang decision on 16 itself. But before furnishing of the original Kavang decision copy, I was on the date of the Kavang decision, I filed an application intimating that I will file appeal. For that, I required original copy of the Kavang decision. But during pendency of furnishing the Kavang decision, the respondent, without enclosing the further copy of Kavang, they have filed appeal before the affiliate authority. But both have filed the appeal within limitation period. So now my appeal is, I have
So
submitted
yours is a cross appeal.
process.
Hmm.
So my contention.
No, Parwana was issued in your, in the,
Yes. Then,
so supposing your grievance is different.
yes. Both have their own grievance.
Okay. Supposing if it is heard, then both will be considered.
That may be, but the procedure is not when
The Kaba.
the
Okay.
numbers are against the same order, they have to be clubbed together
Okay.
and heard on same day. It is the procedure. Procedure may take you to the Indian Parvana. The language itself is clearly reflecting the appeal in respect of the private respondent only. May take you to page 34 is the draft type out copy of it and translated copy. First Parvana was issued, then it was cancelled. Second Parvana was issued by mentioning the appeal of respondent on this. Then I submitted a representation before the authority. Then again they issued this Indian Parvana laws. Page 34 law. Married. An order was issued from the Deputy Commissioner Pasar Leparada directing Sri so and so.
Which one you are reading?
Page 34 laws.
34. This is type copy of 33.
Yes.
33 is clear enough.
33 is, but it is in the local language.
Which is?
Yeah.
Okay. Okay.
This is 34 is the translated.
Yes.
Married laws.
Hmm.
An order was issued from the Deputy Commissioner Pasar Leparada directing so and so HGV of Boritoui to conduct a cover regarding land dispute matter between Sri and so, this is the respondent, and versus Sri Minjo Bagra, he is the petitioner here law of so and so. And pursuant thereto, a cover was held on 16/7/2025 under the chairmanship of Sri so and so so and so. Cover decision dated 16/7/25 was not agreed by the respondent hearing and filed appeal application to Sri so and so HGB Farm Place to conduct a inter-place level cover under the chairman. After receipt of appeal application from so and so, a parvana was issued on so and so, fixing a cover to be held on 30/8/2025 at Pasar Bangodera. But the respondent was not present. I was the respondent here. And due to the health problem of so and so, Sri Pagli Doke, GD has been appointed as a Kavang chairman to continue the Kavang. Therefore, this Parvana too has been issued in continuation to the earlier Kavang Parvana dated 30/8/25. And Kavang members are directed to attend the meeting without fail to settle the dispute amicably, and also directed both the complainant and the respondent not to be absent. The applicant and the respondent are directed to bring their own witness, evidence, and documents to show during the Kavang proceeding. Venue, so and so forth. So, Lordship, as my Lordship has rightly pointed out, both will heard on the same day. But, Lordship, the procedure is when more than one person filed an appeal against the same order, then that both appeal has to be clubbed together.
So where is your appeal?
My appeal, Lordship, at page number, it starts from 80. 80 is the appeal of respondent, and thereafter 82 is the my appeal of 82, 8 below.
80 is,
80 is the appeal filed by the respondent.
okay,
Only 2 pages appeal because they didn't enclose the cover decision. And the petitioner here in file is appeal on 24/7. The bank decision was passed on 16 and appeal was filed on 24. 82.
yours was filed on 24
24.
and
Respondent filed on 18.
filed on 18.
Yeah.
Okay,
But on the date of the bank decision on 16, I had filed with registration. Intimating regarding my intention to file appeal and asking for the original copy of the bank decision so that I can enclose in my appeal. But it was not furnished. So during pendency of that application, they had filed.
so what is notice?
Notice and notice they have fixed the bank to be held on 1. Just October law. And I have received this Parvana on 20.
Mr. Jalali, Line Counsel for the petitioner. Stop it. By filing this application under Article 227 of the Constitution of India, the petitioner challenged the impugn its order or Parvana
Parvana law, second Parvana.
for second Parvana dated 5/6/2025 issued by
Losses. Actually, getting probably reflected. That just down below law, page number to down law. Second cost cycle is the correct date and number law.
okay, second impugn second Parvana
Yes, this is the correct.
dated 21/9/2025 issued by the Inter-Village Territorial Customary Court Customary Court or Apex Customary Court Bastar Leparada Court, Basar, Leparada District. Whereby the Keba date has been fixed on 1/10/2025 in respect of the appeal filed by the respondent against Keba decision dated 16/7/2025 passed by
Grace level.
where? Village level? Where? Which village? Where is the where is that order?
The bank decision lawsuit, impugn the decision. Cover decision lawsuit, it pays 66 onward.
66.
Page 70 is the, and
No, the decision.
yes, cover decision. Also.
Yes.
Translated copy is 74 plus. Customary court of Gori place. The part by the customary court of Gori.
Okay, decision dated 16/7/2025 passed by the customary court of Gori village, Leparada district, Basar. Stop, Para. The land council for the. So the contention of the petitioner is that on where was this order? This Keba order?
Parvana.
No, Keba order.
The first about it.
Yes,
7, 4, 7, 5.
7. Sure. This is Keba order.
Yeah. 74.
Okay. That being aggrieved by the Keba order dated 16/7/2025, both the petitioner and the respondent have filed their respective appeal before the Inter-Village Territorial Customary Court or Apex Customary Court, Pasar Leparada District, Arunachal Pradesh. However, the customary, however, the Inter-Village Customary Territorial Customary Court has issued Parvana only in respect of the appeal filed by the respondent. There are, have you also filed subsequent application?
Yes.
Okay.
I intimated them that my appeal should also be clubbed together with them. My representation at 10008 looks.
While the appeal filed by the petitioner, despite of submission of reminder, has not been attended to. Stop. Para. The land counsel for the petitioner submitted the appeal, both the appeal was filed against the same Keba decision dated 16/7/2025.
Yes.
And therefore, the Inter-Village Territorial Customary Court or the Apex Customary Court, Basar Leparada, ought to have clubbed both the appeal together and taken up for hearing. And stop. And by not issuing, not admitting the appeal filed by the petitioner and not issuing any Parvana in the appeal in the appeal filed by the petitioner, just leave that. And by not issuing the Parvana, the Inter-Village Territorial Customary Court has also not included Keba members from the petitioner's side and thereby cause prejudice to the petitioner. Stop. Para. What I will do is we'll dispose of in the motion stage only, directing the inter-village territorial customary court to club together and hear it together. Prima facie it appears because this is against the same KEBA decision appeal.
Lordship, another ground, by another ground is lordship. What is the next of procedure? When both the parties are from two different districts, then the equal numbers of KEBA members have
Okay, the land counsel for the petition submission when
only the
in the appeal file against the KEBA, the inter-village territorial customary court ought to have directed for equal number of equal number of KEBA members from both the parties. However, in the instant case, the inter-village territorial customary court has selected KEBA members only from the respondent side. Okay. So what I'll do is I'll direct the inter-village territorial
clubbing of both the entities. And I don't think we get numbers of KEBA members from both the parties. That is happening.
from the upon hearing the land council for a petition and on perusal of the record, it appears that both the appeal arising out of the decision, the KEBA decision dated 16/7/2025, and both the petitioner and the respondent have filed appeal before the inter-village territorial customary court or apex customary court. Under the circumstances, the inter-village territorial customary court ought to have issued a club both the appeal together and taken up for hearing together. However, in the instant case, prima facie it appears that despite of the appeal being filed by the petitioner, the inter-village territorial customary court has issued for one only in respect of the respondent and not attended the appeal filed by the petitioner. So, in view of the above, this court is of the opinion that for proper adjudication and for dispense of the justice, both the appeal required to be clubbed together and taken up together as both the appeal as filed being agreed by the customary being agreed by the KEBA decision dated 16/7/2025. Accordingly, this court accordingly the inter-village territorial accordingly this court is accordingly this petition is disposed of at the motion stage with the direction to the inter-village territorial customary court or apex customary court Pasar La Parada to club both the appeal filed by the petitioner as well as by the respondent together and take up both the matter together by inviting equal numbers of KEBA members from both the parties. Okay. In accordance with the law. Okay. And by fixing, okay, in accordance with law. Stop. Huh? As a result, the Parvana. Date is 21/9/2025, fixing the kebab on when it was fixed,
110.
1/8, 110. Where do we find, where is that order?
Lordship 34 is the title. This Parvana was issued on 21/9, and then next 35, it's shown the venue, date, and time.
30?
35.
No. Okay, this is,
Venue, date, and time.
date on 1/10/2025 stands. Is set aside, okay? The last portion, the direction for him, an equal number. Okay, I'll include it. Okay. With the above this petition stands disposed of, okay.
Item number 3.
Your Worship. This is item number 3 and 4 in the same, because you're the same FIR. And Your Worship, this is the matter of allegation by the complainant for the misuse of the user ID, GST user ID and password. And second, there's a lapse in the arrest, during the arrest. So this is the first, Your Lordship, this is the allegation which is made by the complainant, that the GST user ID. So this is the exclusive property of the complainant, person who have this user ID and password. And because there's a process that whenever we use the user ID, put the user ID then password, then there's one OTP which is coming to the phone in the mobile number which of the user, and after putting that OTP only, then only the transaction happen. Now there is an allegation in the complainant that myself has used that his user ID and password, but there is no agreement, there's nothing. And the firms which he has mentioned, I am not the partner in that firm. I am not. There is no agreement.
Allegation is use of,
User
user
ID
ID.
and GST user ID and password.
okay.
User ID.
What offense was committed?
1 second.
Standing counsel. So we are
This is bail application.
a bail application,
bail-
but they have their own standing counsel also.
In the bail also they will appear.
Yes,
How?
they will. I'll inform him. Call for CD.
And second, Your Lordship, I just want to mention that there is a senior lapse in the arrest, because the arrest was happened from the Assam.
What is this 316? 316 is equivalent to which IPC?
Nothing is enclosed here.
Hmm?
Nothing is enclosed here.
That is in enclosed?
Yes, only business is standard. Hereby,
Yeah.
it is in page
Your Lordship,
29.
there is the Arunachal police went to the Assam and they arrest myself, and without any the Arunachal police went to the Assam and without taking any remand.
This is not FIR.
FIR was filed.
The FIR is in the page number 23 years.
Where is the content of the FIR? Okay.
page 26.
Okay, we'll call for the case diary. When he was arrested?
he was arrested, Your Lordship, from the Assam, from the Harmothi. And, Your
When?
on dated 3/9/2025. And there is no transit remand was taken. And there's no, and the Arunachal police didn't inform the Assam police regarding the arrest. They had no officially, there's no notification, there's no any information to the authorities of the Assam police that this arrest was taken. And there's no arrest remand, transit remand was taken. And as per the Supreme Court, Your Lordship, there's order in the Priya Indoria, there's a transit remand is required. But this is a violation is there and there's nothing. And second thing is, Your Lordship,
So
this
where
is
is
the
the arrest memo?
arrest memo is in the
Page 20.
21.
page number 21, Your Lordship. And if you see the 19, it is the 19. Sorry, in the page number 22, Your Lordship, the place of arrest near the outpost of Harmothi. It is in the Assam, Your Lordship, and in the this accused
Mr.
channel.
Mister,
Yes,
Mister, you are Mister?
I'm Amrit Singh.
Hmm?
I'm appearing for Your Lordship that
Okay, your good name, please.
my name is Amrit Singh. Oh, I am appearing for the Renu Sonar and Santoshi Rai.
Okay. Your name is not in the course list.
Yes,
Have you filed
the
wakalatnama?
Wakalatnama is filed by my.
You have filed.
Yeah, Wakalatnama is filed.
Have you filed wakalatnama?
Yeah, by Wakalatnama is filed by.
Have you
My-
signed wakalatnama?
No, my name is not there. His name is there.
You have not signed wakalatnama.
No, I'm not saying.
Uh,
His
Are
name
you
is
senior?
there. His name is there.
Then he is not authorized to give the reports.
On what basis you are arguing the matter then? If you have not
Wakalatnama
signed
is
the
signed by him, Your Lordship.
Your Lordship, I have signed the wakalatnama.
Okay, you will sign and he will argue. Why you have not signed? If you are arguing the matter, you
Your
should have
Lordship,
signed.
because I'm not from here, so I'm from Delhi. So I think that because the advocate was enrolled in the Bar Council of here, only they only signed the Wakalatnama.
You signed the wakalatnama.
Okay.
Mr.
My name is Amrit Singh, Your Lordship. Amrit Singh.
Mr. Amrit Singh, you need to sign wakalatnama
Sure, sure.
if you are going to appear.
Okay, oblige you.
Are you designated senior?
No.
Do you know that wakalatnama is to be signed if you want to argue the matter on behalf of the petitioner?
Because Your Lordship, I think that because it's another state, so maybe only the bar member of Bar Council of this member only they will.
So you are from Delhi and in another state, Delhi wala will be
Because I'm
allowed.
in the Bar Council of Delhi, I mean, so that's why I didn't. But I will sign it. Your Lordship.
Not counsel for the petitioner.
I will inform the standing council. This
Why?
GST standing council.
Your Lordship,
Why?
I will
Why? This is in a bail application.
no, but
Who
this
is
is
to report?
pertaining
Your
to
standing counsel.
GST matter. This is
This is not
pertaining
civil.
to
This is not civil matter.
pertaining to GST matter.
Your Lordship, just yeah,
There was some fraudulent
yeah, just
transaction was done in GST transaction user ID.
but it's a bail matter.
That was some fraudulent transaction was done.
It's a bail matter, and there's one serious lapse in the prison which I want to mention, Your Lordship, with your permission.
In
person
meantime,
suppose-
city may be call for. I will inform the this standing council. She's
Your
They
Lordship,
can assist you. They can assist you if you
Kipa Tanya.
want. If they want,
He is Kipatanya.
they can assist you if they want. But supposing if there is a violation of in the education department, you'll call the teacher or headmaster of the school.
No, he says
Or-
because this is pertaining to the GST matter.
But then you see, he has filed bail application, the person has been arrested, he's under the custody, he is seeking bail for his release. And if he had an objection, they can assist you, you are additional PP and additional PP.
Yes,
represent the
of course,
state.
I'm there
Yes,
in my
state has been
position
impleaded.
post, but for that purpose, they have appointed their standing counsel also.
This is a bail application. And there's a one senior lapse in the prison, your lordship, I just want to
Yeah.
mention.
The petitioner filed this application under section 483 of the BNSS, praying for grant of bail to the accused who has been arrested in connection with Nahalagan PS case number 83, 2025 under section 316 within bracket 4/3 within bracket 5 BNS 2023. Stop. Issue notice, call for the scanned copy of the case diary.
Yes.
Since Mr. G. Tadao, Lane Council, Lane additional PP, appear and accepted notice, the notice upon the state is waived. List this matter immediately after the entering
Uh,
summer vacation.
Your lordship,
Yes.
I just want to mention this. On the date 23/9/2025, there's a one person named Yasin Ali. He went inside with the permission of the judicial magistrate, that he said that I'm the wife of the alleged person, and the prisoner authority had allowed him to enter. So I just want to ask your lordship that how a male person who just get a permission that he's a wife of both the alleged accused. So there's a senior lapse of and he get inside in the prison and threat myself. So
This can be allowed.
So your lordship, I
This is
just-
a jail visit permission,
your lordship, I just
This is-
request.
jail visit permissions by,
So I just
From
request your lordship that please
Can
give
be
some instruction to the prison authority that from now onwards, they're not allowed anybody, means for myself and my wife, only they allowed, otherwise no other person should be allowed inside the
yes,
prison.
this is,
Make
uh,
prayer before the magistrate.
Yeah. Because there's a mysterious person and I don't know who is this person.
actually, this has to be exercised by the London magistrate. This,
And because
Permi-
your lordship, I
permission.
take the opportunity to just mentioning yourself. Your lordship.
uh,
So your lordship, if you give,
Whether the person is to be allowed or not. It is
no person should be
being dealt-
allowed,
it
only
is
my
being dealt
family
by
and.
the magistrate. You
Because
want,
I don't know, your lordship, I don't know.
you
who-
want that no person should be allowed.
Means my wife and the only advocate should be allowed, myself,
And
others
other-
nobody should be allowed.
how do we pass such order?
Yes, because
Because there is a rule.
I don't know who is this person and he went inside in the.
You don't
same-
meet, you instruct your client not to meet, refuse to meet.
But I don't know, means
Hmm.
your lordship, he went inside and
See,
The accused-
see, this is allowed by the magistrate only.
yeah, yes, it does.
Okay, and then if you have grievance against this, you file appropriate application. Okay, yes, similar order in item
in item 4 also,
3 and 4.
arising out of same FI. Item number 5.
May I please, Lordship? This is a quashing petition in connection to charge sheet number 59/2023. FIR is in page number 17. FIR is filed by my wife. Type copy is 19. May I read out?
Just a minute. This question petition.
Yes, quashing petition. Issue is that This general-
FIR at page,
Page number, lordship, type copy is 90.
okay,
When FIR is that lordship.
okay, register under section,
498 and 325, but after that it's instead of 325, it is 323.
okay,
The lordship is with that my wife has the allegation regarding assaulting to the petitioners in the FIR. Lordship. On the basis of that, police has investigated and filed the charge. File charge is in lordship page number.
323 is compoundable?
It's compoundable. 498 is not compoundable.
No, charge it only three, four,
No.
three,
Charge it is under section 498 and 322.
okay,
So now the issue is that we could not able to file joint petition because my wife has not agreed for the joint petition. So now the thing is that inside lordship, page number 20, annexation, we have settled one our
No.
dispute.
just wait, I can't. FIR was filed, register under section,
498A and 325 earlier, but now 323 instead of 325 in charge.
okay, instead of 325, okay,
Yes.
yes, yes,
So
Then-
this issue has been we have amicably settled. The page number 20, lordship, annexure 2.
but why you have impleaded then as a respondent?
Issue is that lordship. That's the condition of this minds of penalty minds of hand on 18 March 2023, para 6, that the criminal case by the turnover woman who is in case number 52 2022 under section 498 oblique 325 against the husband, the argument Sachitara shall be withdrawn by the complainant wife 3 July.
Where are you reading?
Yeah, page number 20.
What is that?
This is the condition we have already settled the matter. Page number 20.
You have settled the matter?
Settled the matter. Also.
Then why you have impleaded, my question is?
No, lordship, problem is that despite of this, my wife has agreed to withdraw, but now lordship, police has filed the charge sheet before the London Chief Judicial Magistrate. Matter is pending, still not taking cognizance, no trial. But I have repeatedly approached to my wife, let us close this matter, this charge sheet, this FIR. But wife has lordship denied to file a joint petition before the Honorable Court. But we have settled the matter in para 6. It's very clear, lordship. Annexure 2, page 20.
You obtain signature, it appears.
Lordship, I have tried, but she is not agreeing. So now,
Yes,
lordship,
sir.
on my prayer is that lordship, this Honorable Court may issue notice to my wife, lordship, and
Okay.
only this much my prayer now at this stage.
My lord,
This Honorable Court can be decided.
my lord, for that the prima facie case has to be made out. This case is neither on merit nor on settlement. Your lordship will find in para 10 why they are intending to issue
On
notice.
merit only because he has impleaded the wife.
Yes, my lord, may kindly come to page number 10 or para 10 of their petition, my lord.
Okay.
The wife is not ready to settle the matter, my lord. And they have not challenged the case on merit, my lord. Why notice
It
should
is
be
not
issued?
on merit.
Yes, no, it is not on merit, my lord. They are simply saying they have settled the matter a long time back and now she is not ready to quash the matter jointly, so they have filed this application. Whether that can be a ground for quashing under 528, my lord.
Lordship, at this stage, notice may be voted.
You are not saying that there is no case against you.
No.
Lordship, we have, Lordship,
How it is possible?
Lordship, my part, this as per that agreement, 18 March 2023 agreement, I have complied everything. Now the thing is that my finance is not ready for the joint petition for the court.
So she is
Lordship,
not ready only. Then you
Lordship, and
should have
that-
challenged it on
yes,
merit.
Lordship. In that case, Lordship, that at this stage, notice may be issued.
Why notice, my lord?
If not agreed, then Lordship, that matter can be, if there is no answer, then why can we do?
How this court can act like a mediator, my lord?
No, not like mediator.
My lord, may kindly come to para 10, my lord.
See, page number 46, Lordship, very clear. Page number, last page, 40, page annexure 446. See, since that that's my wife has filed a domestic violence case before the Direct Court of Judicial passed by UP also. In there also very clear, Lordship.
Just a minute.
Page-
What is the status? Status in the case?
Is that the Lordship case is still not trial as comments, cognizance not taken. Just-
Process issued?
Charge sheet filed, my lord.
Only police has filed a charge.
Whether process issued thereafter? Process issued?
No, Lordship, police has filed only charge sheet before the,
My question is only, whether the court has issued process?
No, Lordship, it's still not.
Not yet.
Cognizance is also not taken.
When charge sheet was filed?
That's it was filed on as a police record, Lordship, in 22/06/2022. And GR is already, year number.
22.
Yes. 22, FIR is also 2022 case.
My lord, may kindly look into the para 10, my lord.
What is that?
That now, almost 2 years past, still said FIR and the charge is pending before the learned court below for the trial, and which may cause unnecessary disturbance to petitioner in near future. That in this connection, petitioner has approached to respondent number 2 to withdraw of the said case, but the respondent number 2 has not agreed to withdraw the said criminal case from the police station or from the Honorable High Court, despite of the repeatedly approach to her by the petitioner for the sake of family peace and reputation. Whereas the petitioner has done his part of the family minus of meeting settlement terms and conditions dated so and so by honoring the decision of family and relative. My lord, now, where is the prima facie case for exercising 528, my lord? They have not challenging whether 498 is attracted or not. They are not before the court on the basis of settlement. Now, under what circumstances this honorable court will find a prima facie case to issue a notice also, my lord?
Where have you stated that there is no case against you? And there is no prima facie case against
Lordship,
you?
that part I have not
And
said.
therefore,
That part I have not, I came only basis of that settlement, minus of family meeting.
see, learned counsel, please try and understand. If this was on consensus, then both the parties should be the petitioner, the joint petition, if there is a consensus and if the case has been settled, if you are saying. There is a case where the case was not settled, then it is on merit only.
Yes, absolutely.
But on merit, you have at least has to challenge that there is no case against you, there is no prima facie case against you, and therefore this cannot proceed. So there is no prayer, no statement.
Lordship,
So on what basis it will
Lordship,
proceed?
such circumstances, Lordship, liberty may be allowed, Lordship.
That will be better.
go the better.
Don't
I will
fight-
convince against my wife
Yes, yes, that will be better.
after vacation.
Mr. Tapu. T. Tapu, learned counsel for the petitioner wants to withdraw this criminal petition with liberty to file affairs if so advised. This criminal petition is dismissed on being withdrawn with liberty as prayed for. Okay.
Mashallah.
Item number 6.
And his presence also be recorded, huh? Additional people. Yes. Yes.
My lord,
Hmm.
this is a joint petition filed for quashing of the FIR and the criminal trial initiated upon this FIR. Your lordship, the petitioner number 1 is the informant victim in this case, and petitioner number 2 is the accuser. My lord, on 10th of August 2024, this FIR was registered under section 379B
On which date?
on 10th of August 2024.
Where is the FIR?
FIR is at page number 20 of petition,
This is on 10,
and 21 is the type out copy.
9. 21. This is FIR.
Yes, Lord.
Okay.
Then case was registered under 379B, 366 and 506 of Indian Penal Code, Your Lordship. And after investigation, Your Lordship, charge sheet has been filed and the trial has been begun at Sessions Court, Alo.
Charge sheet also filed.
Yes, Lord.
Session court.
Yes, Lordship. Because
What is the
366,
offense you said?
section 366, Your Lordship.
366.
Yes, Lord.
What is that?
Your Lordship, 366 is regarding an allegation wherein any woman is taken away forcefully. I am reading the section, Lord.
What is 379?
379B is not applicable. Why? I don't know why this section has been, my lord, registered by the police.
No
This
section is there in
this is state amendment, my lord. This is not for our
Amendment of
state.
Haryana. Your
Okay.
Union Territory of Chandigarh and my lord, Punjab.
Charge sheeted under same offense or?
Same offense, Your Lord.
Interestingly, cognizance has also been taken under 379B.
379B.
Yes, it's not applicable in our state, my lord. It's a state amendment, ma'am.
Yes, state amendment of state of Haryana only.
Where is the order taking cognizance?
Page number 76, my lord.
It seems like, my lord, the learned magistrate has not applied judicious mind, my lord.
Mhm. Not seen the provision.
Yes, my lord. It's a state,
Saying that the prima facie case made out.
Yeah.
Cannot.
there is state amendment in the Gujarat, my lord, 379B,
Okay, so,
Haryana.
so this, there is agreement thereafter,
Yes. Your,
settlement.
yes, Lordship. My lord, here this 379B is not there, so it is not applicable. And Lordship, 366 is also not there because the case is different and the definition of 366 is different, Your Lordship. And Your Lordship, remaining section 506 is non-cognizable and compoundable offense, Your Lordship.
Compoundable.
Yes, Lordship. Part 1. And Your Lordship, this was here the petitioner number 1, that is the victim informant, was the girlfriend of this accused, Your Lordship.
Then 366 is not applicable.
Yes, Lord. Here, Your Lordship, because of some, because Your Lordship, this accused and the informant were in relationship since 2023, and the family member of this victim were not ready for the relationship. They had no approval for the relationship, Your Lordship. So, this victim and the accused went to Tinsukia, Lordship. So,
This is pending before which court?
Sessions Court, allow, Your Lordship.
So
And-
which is sessions tribal?
No, no, my lord, it's because the chief judicial magistrate. My lord.
For cognizance taking only. Thereafter, this has been committed to Sessions Court.
Okay.
Now, page 77. Let the case record be transmitted before the Honorable Court of District and Session Judge allow.
Whether says exclusively tribal, it's a committal order.
Yes, sir.
Page 70.
76, 77. 76 is the hearing date of 6/12/2024 when this cognizance was taken. And thereafter, this matter has been committed to Sessions Court.
Now, here in this case, my lord, I will take back my word. I cannot say that the concerned magistrate has not applied its mind, because since normally it's well settled that, my lord, the concerned magistrate has to active passively, my lord, not actively while taking cognizance when it is session triable, because it is in a committal stage.
Where it is stated, where is the committal order?
Committal order, my lord, it's in same, my lord, same order, my lord, 76 only, the last part, my lord, 77. Let the record be transmitted before the Honorable Court of District and Session Judge for trial and dispose thereof. Page number 77.
Okay, thereafter. This was on 12/24. Chief Judicial Magistrate.
25. Again, my lord will find in page 78.
Page 78, Your Lord. It's third paragraph.
Okay, 66, 366.
Yes.
Here they have clear, made clear.
366 session triable, but your lordship, the other section will also be taken up together.
Yes, that is there.
Yes, my. Now the next order is in page 80, my lord.
So record need to be called.
Yes, Lord. And your lordship, here thereafter that this informant victim and the accused got married, and they are now living happily. In the meanwhile, this summon was issued by the Court of Sessions Court Alo.
And all the
Yes,
records are
made
here.
appeal.
Charge not yet framed.
No, no, it's for CC only.
Not yet.
Fixed for CC.
I think he will be discharged only, it appears. If
Yes,
there is nothing.
they can advance their argument there, but if they are coming on the basis of your settlement, that would be different aspect, but there also they can try.
Yes. So here, I have filed this petition on basis of the settlement, your Lord.
Where is the certificate?
Page number 86, your Lord. This petition for quashing has been filed jointly by the parties lordship for quashing on settlement.
Long order. Long settlement.
Yes, my lord. It seems like they both were in relationship, my lord.
Yes, since 2023. And they got married, and now, your lordship, in the next month of November, you see they are expecting baby. They are husband and wife.
Well, then your lordship, if they are husband wife now, then your lordship, there is no point to let
I
them
have-
roaming around the cloud of
Yes.
litigation, your lord.
I have enclosed the mother and child protection card also, Lord. The doctor has said that the expecting of the delivery is on 9th of November 2025. So this petitioner, number one, being the victim informant, and the accused, that is the petitioner number two, has amicably settled the matter, Lord.
What is the, just 366?
My 366 is the kidnapping, abduction, or inducing women to compel her marriage, etc. But now they already married, man.
And this section applies to a case, your lordship, where any third party forcefully taken away any woman for the purpose that she should be forced for marriage, or she should be forced for sexual intercourse with other person, not for himself, your lordship. While granting bail, your lordship, the honorable court has also observed in the bail order that section 366 seems to be not applicable in this matter. So if the section 379B and 366 is taken out, your lordship, then only section 506 left out. And 506 is a non-cognizable and compoundable section, your lordship. And now, since both the parties has amicably settled the matter and his joint petition has been filed, your lordship.
Now, 366. It appears made out.
Punishment is up to 10
He
years.
successfully married thereafter.
Yes. But my lord, the peculiar circumstances is if they both were not married, then it will substance. But your lordship may have seen the settlement deed also, but they have admittedly, they have admitted that they both were in relationship, my lord.
Now, see, this is the case where he abduct the girl or woman to compel her
For marriage.
marriage. And he succeeded also.
My lord, now
And then
when they
it appears
settled,
that the case under 366 made out.
Lordship, they were in live-in relationship since 2023.
No, whatever may be.
Yes, so,
But then the woman who was abducted, immediately after abduction, she lost complaint.
and Lordship, she was not taken for marriage purpose, your lordship.
But married.
Marriage
But then her
happened,
allegation is that only.
no, the FIR is very clear, lordship. For marriage purpose also, she was not taken.
Then she was taken for what?
They were girlfriend and boyfriend. On the previous night, they had a quarrel. So only to ease the situation, your lordship, they had went from Alo to Tinsukia, then returned on the same evening, your lordship. Their marriage was disturbed by the non-approval given by the family members of the girl only. And thereafter, this victim girl herself convinced her family member for the marriage law.
Okay. Can we, you have annexed her police statement?
Yes, lordship.
Because the allegation is not that it appears FIR. Let us see the police statement where. Victim statement.
Page number 51, type out with the page number. Statement is in 49, but the type out is 51.
Admitted. It's because of family interference, my lord. Seems like.
Oh, please, long statement.
No,
Oh, it's long statement.
yes, my lord, will kindly see page 55, my lord, the type copy.
Hmm.
Then what would your name, your relationship with so and so, as per record, marriage affidavit so and so submitted to me, you are considered his wife. We are in living relationship till now. I could not accept of marriage proposal with him until my family gives consent.
Where do we find that?
Your lordship, will page number 55, my lord,
Yes, it's there.
55. The type copy, my lord.
Yeah. Did you marry demo? Did you marry so and so in the court?
Yes, your lordship. That part is, did you marry so and so in the court?
I did not.
I did not. When I was in so and so, he has insisted to stay with me since we love each other. Being living together, my family had learned some past instances of his quarreling and beating his girlfriends. They had settled the issue amicably outside the court. Besides, his being a school dropout and his hot-tempered nature made my family disapprove of him. He learned their opinion and started insisting me to get married and do the lie-up ceremony soon. I could not go against my family, so I refused to go ahead. He has a quite stubborn nature that found out later. If he desired something, he would go after getting it done by hook or crook. He was doing it with me then. On my refusal for lie-up, he began forcing me to court marriage. He tried to pursue me. To this also I had refused. He got agitated and started giving me threats to kill himself. With his such threats, since I cared for him and did not mean to get him harmed, I agreed to sign an affidavit of marriage to calm him down. None of my family were informed about it. Took along one of my Bagra relative working there to accompany us without telling him any detail. So now questioner. Then what would your name, your relationship with so and Bamo? As per record marriage affidavit copy submitted to me, you are considered his wife. We are in living relationship till now. I could not accept of the marriage proposal with him until my family gives consent. But before situation could be better for them to respond positively, he has been causing me tons of trouble one after another, giving reason for them to disapprove of our relationship. Our marriage is yet to be solemnized. So I do not consider his status as married. However, to maintain the sanctity of for being living together, sometimes refer myself as wife. As per law, we are not yet married. Now,
So what do we do?
Your Lordship, Your Lordship, every record is there. And even the 161 statement clearly shows that they were in relationship, my lord. And now they have approached this court squarely on the basis of settlement. And one of the section is also not attracted. So, my lord, it is motion stage also, Your Lordship. If Your Lordship inclined, matter may be, my lord, interfere. My only prayer would be, my lord, that clarify regarding section 379B, so that we can communicate it to the concerned authority, my lord.
So the charge not yet framed. When it is fixed?
It's on 23rd of October.
23rd of October?
Yes.
Can you fix thereafter? Let him
Yes,
just
that
take
can be
1
done
month.
also. That-
Because this automatically will, of course, we may have to allow, but then let us give one chance.
Yes, so that that section will
They
also be
They
clarified.
also understand
Yes,
that this section doesn't attract. Okay. We'll just call for the scan copy. And in
Yes,
the meantime, if nothing happens,
Yes,
when
Your
it
Lord.
comes again,
Okay.
by fixing it on November, October, November
23rd.
first week or October.
23rd.
Then if it is on 23rd,
That record,
30, then, my lord.
okay.
Then the record will also come, my lord.
Had Mr. Ketas,
Yes, Ketas.
planning council for the petitioner. This application under section 528, to read with section 529 of the BNSS. What is this 529?
Five. 529, my lord. It should be 528.
28 and
29, your lord. No, 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 no. 529 will not applicable, my lord. 528 only.
that's it.
Regarding the expeditious disposal, supervisory power of the High Court, my
Hmm. Don't put unnecessary. 528 of BNSS has been jointly filed by the informant petitioner number 1 and the accused petitioner number 2. Seeking, invoking the inherent power of this court for quashing of the proceeding of. Well, what is the number in the session code proceeding in session case number 04/2025 within bracket ALO arising out of the ROP and WPS case number 08/2024 under 2024 stop, huh? Okay, issue notice, call for the scanned copy of the trial court record. Since Mr. Lana additional PP is present and accepts notice on behalf of the state respondent, appears no formal notice need be issued. tough, huh? List this matter. On,
My lord, on 30, my lord.
okay.
23rd is the date, next date fixed.
30.
Right.
30
Deeply
October.
obliged. Deeply obliged.
Item number 7.
May please, your Lordship.
Yes, what is this?
Lordship, this is the application filed under section 528, praying for the quashing of the FIR under the ground of settlement between the complainant and the complainant who is petition number 1 and the accused person who is petition number 2, Lordship. In the last hearing, Lordship, the hard copy of the FIR was not annexed, thereby the direction was given. Now we have filed one additional affidavit where annexure number A provides for the hard copy of the FIR, Lordship. Lordship, the section which is alleged is section 78 close to BNS. It is offense for committing stalking. Lordship, it is non-compoundable but bailable in nature. And the second section is Lordship section 66E of IT Act 2000. It is both bailable and both compoundable in nature, Lordship.
FIR was lodged on
9th September 2025. And the
9
accused,
September
yes, Lordship.
2025.
Yes, Lordship.
Okay. Then
Then on the next date, the accused was
it
arrested.
is still under investigation.
Yes, Lordship.
Whether the accused was arrested.
Yes, Lordship. He was arrested and he was produced before the London magistrate. But as the section levied is bailable in nature, he was enlarged on bail.
Okay.
Now, Lordship, they have made an agreement where the complainant has clearly stated in paragraph number 3 that
Now, how do we interfere with the investigation at the in the investigation stage? We do not know.
Lordship, the section which is alleged is, Lordship, my humble submission is that Lordship, the sections are not heinous, Lordship. It's
Maybe,
only
but then-
stalking, Lordship.
Maybe. But then the matter is still under investigation. Have you filed withdrawal of the complaint before the IO?
No, Lordship.
You filed.
Because, no, Lordship, because the one section is
You said that it's
non-compoundable.
a compoundable.
One,
The
the
one is
seven-
compoundable and
Yes.
one is also bailable.
the first section is non-compoundable but bailable in nature. Both the sections are bailable in nature, but the second one is compoundable, but first one is not compoundable. That's
Okay.
why.
So if it is not a serious one,
Yes, Lordship.
ask the informant to file for withdrawal of the FIR to show that this was done. That the informant really wants not really don't want to continue with the
No, Lordship.
case.
That is the reason, Lordship, we have filed under section 528. It's the inherent power, Lordship.
No,
The complainant, Lordship, doesn't want to pursue, then what if the police will give objection again unnecessarily? That's why.
no,
Lordship,
that
we
is
have
why
filed.
you so see normally
Yes, Lordship.
at the investigation stage, it's very difficult. You have committed certain offense and then enter into agreement. We do not know what had happened, how, what was the situation of the informant. And now you want the quashing of the FIR itself. The case is still under investigation. Police has, you see, set the law in motion and under investigation. If we interfere with, it will be too much on the part of the court also. You file one application, the complainant should file one application before the IO. And thereafter, if nothing happens, because it's question of 60 days, within 60 days or maybe very less than that, the police will file charge sheet. Then when it is before the court, and then if the party agree, we'll set aside and quash. But then at the investigation stage, this court is not inclined to interfere with the investigation of the case. And then if you have also not showing that the complainant really doesn't want.
Yes, I
So-
have, Lordship.
That is why you file one withdrawal petition before the police, IO. Although we have lodged complaint on such and such that alleging accused for commission of so and so. Now we would withdraw. We would like to withdraw. And then police will not continue with.
Lordship,
Now see, it will be too much on the part of the court to make it so easy that you file. This is of course not very serious, it appeared, but then in a serious case also, the people will start coming. And there is an order, there is a judgment where in the investigation stage, it cannot be until and unless, of course, there is totally there is no case. Here is the case where there is an allegation, the child or what? This is,
yes, Lordship.
she is in trauma.
No, Lordship, it's not like that. He has clarified.
Continuously you stop again. And then camera, photographs, all
No,
those.
Lordship. It has, like, the complainant has clearly clarified that out of the FIR arose out of the misunderstanding. Because, Lordship,
They will say now.
no, Lordship,
But
because
then
my humbly, I like to submit, Lordship. I am also a father. I have a daughter similar to him, the complainant, and he is my neighbor only, Lordship. Now, because of this FIR, I'm getting ashamed in the society. But actually, the thing had not happened. But also, Lordship, the allegation is upon me. I was arrested. The next day, I was enlarged on bail.
Okay, you
Lordship.
file withdrawal application before the IO of the case.
Lordship, they will never agree.
Who?
The police.
No. Get it, receipt of the withdrawal petition.
Lordship,
Receipt of the withdrawal petition. Then this court also will believe that, yes, the complainant really want to withdraw. Now, here is a case where, in the criminal case, you see, the person who is stronger will always compel to withdraw the case also. So we don't want to interfere with, at least during the investigation research. If the case is filed, after investigation, if the case has been filed into charge sheet before the court, then entire matter finished, of course, with regards to the investigation. There, in that case, on perusal of the record, will consider.
yes, Lordship.
So
But
ask him to make
Lord-
one application for withdrawal application if he really don't want to pursue it.
But Lordship, what about my reputation in the society? I'm aged about 40 years, Lordship. And allegation
No,
is
no, no.
upon me, Lordship, that I am stalking
If it was if it was a false complaint, he is bound to make an application. If it was not a false complaint, then you have to suffer.
no, Lordship,
At least.
I was sitting in my shop. The police came and they dragged me to the police station, which I cooperated fully, Lordship. But now is that I'm not getting a proper prestige in the society because I cannot, even the shop owner has removed me from the shop,
The
Lordship.
father, what interest the father will have
Yes, Lordship, I
Aga-
also have a daughter like
against, because by making such allegation against any persons, alleging the person of doing something wrong against his own daughter, he is also risking the reputation of his own daughter. Now, that cannot be false.
No, Lordship, that is why
Normally,
that agreement
normally.
is executed between them, Lordship.
Maybe, but then that is why I'm saying.
Lordship, in page number 28, I just want to read, Lordship.
No, what do you say? Can we interfere at this stage?
Lordship is actually suggesting the Lordship that he can go and appear before the, for withdrawal application, he can
Just-
submit.
Just
lordship.
make one application, get it receipt, if you really want to pursue it.
Right.
And then, normally I don't, this court is not inclined to interfere while the case is still under investigation.
So that on next that we can produce updated case diary also.
Hmm. For what?
So lordship has suggesting him to appear before the IO to withdraw the lordship, so that whether that had been initiated or not, lordship.
See, FIR was lodged before the police registered the case, law set into motion, and then it involved to it, the state exchequer also. But for no reason, court direct, while the case is still under investigation, we do not know how much serious it is. Seriousness, we do not know, because the IO would be the right person who would know. Now, suddenly set aside and quash, when the case is still under investigation.
Okay, Lordship,
And if it happens to somebody who really was compelled to sign the agreement, it will be very difficult.
no, Lordship, through the full consent only.
I believe you, but
Yes,
then I
Lordship,
don't
I'm
believe the
not lying,
paper,
Lordship.
some of the paper, okay?
Yes, sir.
So, you make that application and file afresh. After that, how long it was, the complaint was lodged recently, 9 only.
Yes, Lord. On 18, we have executed the deed of mutual agreement, Lord.
Now it is, now this court, if you want to take chance, I can keep it pending. Otherwise, this court is not inclined.
I'll do as the court direction.
Hmm?
As the Lordship suggests, I'll do it.
Hmm.
I'll file one application before the investigation officer and bring the receipt here in the next date, Lordship.
That will be. You want to withdraw and file afresh, enclosing all those, including the FIR. That will be better, because it's too early. Premature.
Lordship, again, thereafter-
Immediately after filing and an investigation, then you file this application.
if it
You
pleases
better
Lordship,
file afresh. Or what do you say?
Lordship, my humble submission is that Lordship, now this, again, because the matter is not charge sheeted, again, what if the CD will be called upon? Again, I have to wait, Lordship. Already, from
CD will
tomorrow onward-
automatically call, the updated CD,
Yes,
updated case diary will be called for. But then FIR, I don't, this court is not inclined to set aside a FIR. Or that will be, you see, interference with the investigation of the case. Don't want to interfere with. And probably it is with the other brother or sister judges also. You better withdraw, file afresh.
Lordship, I'll file an additional affidavit with the receipt of the application, which shall be before the investigation officer, Lordship. It is the same thing.
It's all the same, it's all the same. It will be better. You just wait for some time and let the investigation complete and file. He was arrested. How long he was there inside? Immediately released.
24 hours, Lordship. Within 24 hours, they have to produce before the magistrate first class, Lordship.
Oh, what he is doing?
Now, because of this,
The petitioner is, what is his profession?
profession is, Lordship, I'm a salesman.
Trouble.
Lordship, because of
Okay.
this FIR, my job has
So,
also been terminated, Lordship.
I don't want to interfere with the investigation, so case will be dismissed. Or what do you want?
I want, Lordship, order may be reserved. I'll file the additional affidavit of the application which shall be.
Order will not be reserved. If the order is to be passed today, it will be dismissed only. It's an initial stage of investigation. Don't want to interfere with. It's premature. You file a press or dismiss
File a precedent along with
along with that.
annexure.
Explore that. Okay. Then in that case, if really there is no case against you, police also will not proceed with the investigation and will submit the, or else you can also request the complainant, the victim would like to give a statement before the magistrate. Give one statement, there was nothing as such. Automatically he will file final report. If what you are submitting is correct. Okay?
Lordship,
Mr.
I'm submitting very fairly, Lordship.
Yes, yes. Mr.
As in
Hmm?
As in
As in the learned counsel for a petitioner. He wants to withdraw this criminal petition with liberty to file afresh after incorporating certain documents. The prayer is allowed. This criminal petition is dismissed on being withdrawal with liberty as prayed for. Okay.
Obligado.
obliged.
Yes. Okay. Okay, we'll continue it. To
Item number 29.
nine. Yeah.
Yes, yesterday I have filed additional affidavit, madam, stating that the case is after the charge sheet has been forwarded to the learned CGM UPIA, it was again endorsed to the judicial magistrate first class for the trial, as per bide order dated.
What
Zero-
is this case about? 38.
Yes. On order dated 08/05/2025, which was registered as a GR case number 1058 oblique 2024, my lord, which is pending before the learned judicial magistrate first class. And my lord, moreover, this the order dated 08/05. It was supposed to I have annexed in the additional affidavit, but it was I have received lately. So here I am clearly afraid that this GR case, I mean Papu P's case number oblique 73/2024, which has been subsequently registered as a GR case number 1058/2024, which is pending before the Honorable JMFC Court may be disposed, I mean set aside and quashed,
Which is to be?
which is to be setting aside and quashed.
Why?
My lord, the parties have already, they have entered settlement agreement, my lord. May I take, my lord, to my main case, petition, my lord. Page
What is the
58
what is the offense alleged against accused?
offense against my lord is section, my lord.
74. What is 74?
74 is for, my lord,
Assault.
it's for assault or use of criminal force to the woman with intention to outrage her modesty.
Akin to which IPS?
Yes, it's
IPC?
it's 354.
Hmm?
354.
354.
Yes,
Okay.
this is the only non-compoundable section.
Okay. rest
Otherwise,
are
the rest are
compoundable.
compoundable section, my lord.
This and dispute is between
Between the wife of, between the petitioner number 1 and petitioner number 5, my lord.
Okay.
This is the girl.
1 and 5.
Yes, 1 and 5.
And
The
what about this other?
Others allegation is that 1 and her group is assault the petitioner number 5.
Where was the FIR? Just let us see once.
Charge sheet is also been filed, Lordship.
Hmm?
Charge sheet also there, Lordship, charge sheet.
Charge sheet also filed.
Yes, my lord. FIR is in serial number,
Okay.
page number 20.
Yes. Hmm.
May I read?
Just a minute. Huh?
20.
What is the punishment under the 76? This one
74 is,
or
Lordship,
74?
1 year up to the 5 years, Lordship.
Okay.
Extend to 5 years.
Okay. After filing charge sheet, it was
Charge sheet,
endorsed
Lordship.
to judicial magistrate first class.
Yes,
Yes, my
Lordship.
lord.
So where is the order of the judicial magistrate first class?
Yes, I have just now. I have just now I given you.
Newspaper.
Actually,
Why you have handed over?
yes, that is supposed to I annex in my additional affidavit, my lord. But this order was certified copy was received by lately, so that's why I have not made annex.
This is chief judicial magistrate only.
Yes, he endorsed to the judicial magistrate first class for the.
Yes, where is the
Right.
order of the judicial magistrate first class thereafter?
Thereafter, your honor, it is not. It is in still. It has been not take cognizance, my lord.
Not yet registered. Immediately after receipt of the record, it has to enter.
No, it is not yet taken
So
cognizance.
record and it has to register.
Even
It is
yes,
no longer with the chief judicial magistrate. That is
Yes.
your prayer.
yesterday also we have asked for the any more order, but they've only furnished this order dated. Just now I've submitted.
Maybe Lordship, Mehta did not put up before the MFC court yet, Lordship.
Still did not put up here, my lord.
Now then it has gone out of CJM, not yet reached to JMFC. It's still on air.
But my lord, it has been already endorsed to the JMFC, my lord.
Yes, but it is no longer with the chief
Yes.
CJM.
That is true. But the matter has been already settled, my lord. Now,
Have some patience. Let the case need to have some address where we can change, where the direction can be given. This record you have received from which court? Can I additional PP? This record you have received from which court?
Lordship, maybe Lordship, CGM or Lordship, JMFC, Lordship. JMFC, Lordship.
Whether the JMFC and CGM has the same GR number? Cannot
Yes.
be.
yes, my lord.
Yes, Lordship.
The case number,
Yes, everything. GR number has been used as a case number. Even my lord may kindly may I take to page, my lord.
Mr. Tari will ensure that it has been registered and any order passed or it has been registered before the judicial magistrate first class will not pass any order on air because it has gone out of chief judicial magistrate. It has reached judicial magistrate first class but not yet registered, not yet entered into register. Will not pass order.
But my lord,
I'll grant this court will grant, but then let us not pass such order unless it is settled. Let the case be settled in particular place. Let the case have the address so that we can direct properly. Will not pass such order. Court is not in hurry. You may be hurry, but then court is not in hurry. We would not like to make such mistake. I can pass order, but then we would not like to. The case has not yet reached JMFC. Your last order is Chief Judicial Magistrate only, whereas the case is not with the Chief Judicial Magistrate any longer. Now, in any case, now we have to direct Chief Judicial Magistrate only, whereas the case is not there. How do we direct to the Judicial Magistrate first class when it has not yet taken or not yet entered into the register? It has not yet born. Have patience.
But Your Honor,
And then ask the staff also, if you want to expedite, please register it, list it, place it before the JMFC, or if it can be registered and if they have a registered number, we'll pass order. In the vacation court also I can take up, but then we'll not pass such order. When it's settled, it will be quashed. We cannot give that kind of direction. Have some patience. You are facing any trouble, otherwise the accused, no problem. You are on bail only.
yes,
This will be considered only. But then such direction, this court is a high court, we will not give. Let the case be settled in some place.
but my lord, since only
Now you are on a journey, left Itanagar, heading for 0. We do not know where you are settling. Not yet reached. How do I call you? They are at 0.
but my lord, since my lord, since
Yes, but then you are not. You are also not in urgency. Your case will be considered only because you have a case. No problem at all. Now case is not yet settled. It will take time to issue process by the Judicial Magistrate first class. You will not be disturbed. Any problem? You have a good case, but then this court is unable to give direction on air because I want to give a direction to the Judicial Magistrate first class, but then which case in Judicial Magistrate first class?
the case number will be my lord same GR case number. Will be
No
same,
idea,
my
no idea. But then let at least in the register also, you produce a register also. It has already entered in the register of the Judicial Magistrate first class. Okay. In the vacation court also, if you feel urgent, okay. Both the Land Council for the petitioner, Mr. G. Tadi.
Otherwise, my lord,
Because I thought that you will be producing order passed by the Judicial Magistrate first class. The same order is available, Chief Judicial Magistrate order. Yesterday or day before yesterday, I thought that since you submitted that it has reached to the Judicial Magistrate first class.
yes,
I thought you will be producing order of the Judicial Magistrate first class because it has left the Chief Judicial Magistrate court.
my lord, then this matter may be taken up after vacation.
Immediately after vacation. Okay. Mr. Tadi, Lane Council for the petitioner is present. Ms. L. Hage Lane, additional PT is also present. Stop. Let this matter on the prayer of the petitioner. Let this matter be listed immediately after the vacation, entering vacation. Okay.
Much only.
Item number 8.
My lord,
Yeah.
I want to withdraw this bail application.
Mr.
Gani Gata.
Hmm?
Gani Gata.
Okay, Lane Council for the petitioner has an instruction, want to withdraw this bail application. The prayer is allowed. This bail application is dismissed on being withdrawn. Okay.
Item number 9.
Lordship, this matter, I was on the last occasion praying for release of the action there because this is a already charged sheet case and trial is going on, Lordship. And allegation was that I was lying before the court on the last occasion,
Mhm.
whereas it was a miscommunication actually. I was on the date of appearance, Lordship. Actually, there is the accident. That accident. That accident took place on 20 March.
Mhm.
20 March. Kindly
Okay,
see,
so,
here is the
okay, just a minute, just a minute. There was in order. Okay.
explain the page number 4. Second paragraph.
Page
Page number 4, second paragraph. That is
4
my-
of your
my
petition.
explanation.
4 of your petition.
Yes. This- There is a allegation that I was lying before the court. Whereas,
Yes, ma'am.
accident-
Page 4,
yes, page 4,
para,
para 2,
what?
para B,
Hmm.
para B. Accordingly, it was like this. 23 June, on the date of appearance, when my bail was cancelled. Because before that, 2026, the proceeding was on, court proceeding was actually on 26 March. On the 26th March, someone was issued to the bailor, and against me, there was a non-bailable warrant of arrest was issued. On 23rd, going back, kindly,
You were arrested in execution of the non-bailable warrant of arrest.
not exactly, not execution. It was a, when someone was issued, my bailor told, bailor told me that there is a, someone has come, you have to go to the court. Accordingly, I appeared before the court on the date fixed. That was on 26th June. When I reported to court, my bailor says, I am no longer, I do not want to be a bailor. And I may be declared. Application was filed before the court. Accordingly, I was taken into custody. This is the case. I have talked to,
You have objection.
Your Lordship, I'll just apprise Your Lordship. On the last occasion, Your Lordship had directed to get the registry, the PCR, well, the bail application was filed, Your Lordship. The only issue in this case was that on the earlier occasion, he did not appear before the court during the trial, Your Lordship.
Hmm.
Even after he was granted bail. Only on the condition, one of the condition was violated, that is, he should not leave the jurisdiction of the state of Assam as well as of Arunachal without the prior permission, Your Lordship. Thereafter, Your Lordship, a non-bailable warrant was issued, Your Lordship.
Hmm.
He appeared, Your Lordship. In that point of time, he told the court that he could not appear during the entire trial because he was in Kerala for some work, Your Lordship.
Okay.
Subsequently, Your Lordship, the previous bail was cancelled. Thereafter, he filed an bail application before the trial court, Your Lordship, in which he had stated that he met with an accident and was in Kerala for treatment, Your Lordship. That's when the Honorable Trial Court had held up that on the previous occasion, he stated that he was in Kerala for some work, and subsequently, by his bail application, he stated that he was
He met an
in
accident.
Kerala for treatment, Your Lordship. Now, the
Contradictory statement.
contradictory statement, Your Lordship. Now,
Because of that, bail was rejected.
yes. Previously, the bail was cancelled because of violation of certain provisions, Your Lordship. Thereafter, he
So
had
this
filed
was only punishment for telling untruth.
no, Lordship, that is not exactly the fact. Kindly see the page number 23. This is the rejected bail order. It's clearly mentioned, admitted at civil hospital, Nagaon, Assam. But during the communication with the judge, Special Judge, UPR, the judge was asking that where you were in those 2 years. He says, I was at Kerala. Whereas he was referring to the time after, at that point, after that 26th March. Whereas before the 26th March, on the day when the summons was issued for appearance, that is two events were there. There was a miscommunication in between the accused and this judge, honorable judge. That is why there was a statement that he has clearly stated here that on 20 March,
It was miscommunication between a
20 March,
judge and the
On-
learned counsel, it appears.
on 23rd.
My only
So,
submission before this court is even
I
the
mean, I need to
bail
comply
application is
with
there
after
in the record, Your Lordship. My only submission before this court is that since when the bail is given, Your Lordship, that bail conditions are put forward so that he cooperate during the investigation is
He
in the
violated.
trial, Your Lordship. He violated it, Your Lordship. Now I'll just submit, Your Lordship.
Oh.
My only point is that to ensure his presence during the entire trial, normally the bail with the conditions are given, Your Lordship. He was not present during the entire trial, Your Lordship. His counsel himself.
Now, what is
made
the
a
progress of that?
Now, out of
Right.
the six witnesses, Your Lordship,
Hmm.
5 of the witnesses examination has been done, Your Lordship.
Okay.
This is the 6th witness examination speaks on 6th of November, Your Lordship.
Is there any
Yes,
incriminating material?
it's a case of 21B NDPS, Your Lordship.
Okay.
So now the thing is that during the entire trial, he has not even cooperated with his
That is
own
on for
counsel.
the record.
Yes, Your
Is
Lordship.
there any possibility?
Yes, Your
of his
Lordship. There is
conviction?
possibility of conviction because
Okay.
even he's on his own admission, Your Lordship. He has
Okay.
stated that he also used to take the contrabands as well as he used to supply in the state of Assam
What is
and
the
Arunachal.
punishment?
10 years, Your Lordship. With a
That 10 is a minimum.
yes, Your Lordship.
Extendable.
Extendable.
Not the-
No, there
How
is
long
no
you have
minimum.
been inside?
extendable to 10.
Okay. How long you have been inside?
It is already
he-
after arrest. I have been already 3 months and more.
Okay.
More.
Earlier?
Earlier it was more than 1 month. Before release and bail. Bail condition was I have seen bail condition only the condition
not
that
1
during
month.
the court investigation.
Oh, he has
Right.
deported. Have you
Not-
seen
not-
how many times he has
I'll
deported?
just,
Just a minute.
I'll just
Just a
correct
minute.
Your Lordship.
Oh.
He was arrested on 23/1/2020, Your Lordship.
Okay.
He was released on bail on 4/2/2020. That means he was not even
Okay. Now, thereafter, the trial, in the
thereafter-
trial,
after his bail was cancelled.
Hmm.
His bail was cancelled on 26/8,
26.
26, 23, not 26, 23/6/2025, Your Lordship. That's June, July, August, September.
Till June, I
Uh,
have decided.
okay, these witnesses were examined
Yes,
when he was on bail or after?
on
He
bail,
was
Your
arrested.
Lordship, on bail.
Okay.
He
After
was
his
on
arrest,
bail.
after his arrest, how many witnesses have been examined?
5 of the witnesses has
No,
been
after his arrest, re-arrest.
only one witness is to be after. I'll
No,
have to see
after
the
his-
after. I'll have to see the record, Your Lordship.
So, but then he appeared also. He appeared. He appeared.
No, he did
also.
not appear. Trial went out. Trial went. He was on many occasions. He did not appear without. He was absent without steps, Your Lordship. That's when his counsel himself made a complaint before the court that he's not cooperating, Your Lordship, even during the trial, and his families are also not cooperating with the trial to locate his locations, Your Lordship.
Okay.
Only after non-bailable warrant was issued, Your Lordship.
Nothing. Kindly see the record.
Okay, heard Mr. Itapak, Learned Counsel for the petitioner. I have also heard Ms. Jenny, Learned Additional PP for the state. Do we have the record of when he was arrested?
We have the record, Your Lordship.
Okay, the accused, what is his name? Aswad
Aswad.
Ullah. Aswad Ullah was arrested.
Asadullah.
Aswad
Asadullah. Asadullah.
That's what-
was arrested in connection with. What is the case number now?
Number 31 of 2002. In connection with Bandapur PS case number 01 of 2002.
NDPS case number 31,
31 of 2002.
2022, arising out of in Withdrawal. PS case number 01, 2020 under section 21B of NDPS Act. On when? Initial
He was arrested on 23/1/2020.
23/1/2020,
20,
2020,
and he was released on bail
And-
on
subsequently released on released on bail
4th February 2000.
on 4/2/2020. Stop. The accused was arrested again on when?
you lot.
The present one, 23/6,
23/6,
26,
23 June.
how?
2025.
26 March or 23 June?
23 June,
23 June.
23 June, where?
Yes, 23 June. Kindly see page number 20. Annexure 6.
Annexure page?
Page number 20, Annexure 6. Of
Okay.
that application. Annexure 6.
Okay.
When the bailor was not ready to
Okay, re-arrested
bailor discharged and he has
on
taken back to custody.
23/6/2025.
20.
It was cancelled or after cancellation or?
Cancel. Saying that bailor has already discharged.
Okay, now the petitioner, who is the wife of the accused, prays for stop. What is your ground for release?
Ground is that
Mm.
I am having children and
Okay.
I am the only sole earning member.
On
And I have been inside jail.
the land counsel for the petitioner, some is that the accused has how many children you said? Accused has a wife and children, and he is the only earning member of the family. And what else? Ground for your seeking bail?
Bail is that there is nobody to earn in the family.
Okay,
Yes.
only earn, okay,
Yes. And I have to look after my children also.
okay,
That is the issue. And trial will go on.
okay.
So there is a trial. Already I have been inside the jail for 3 months, more than 3
Mm.
months.
And since he has been inside a custody for more than 3 months at a stretch, prays for release, prays for his release, at stage, and also the trial would take longer time to complete. Therefore, pray for his release. Okay, stop. Para. Miss Jenny, learn additional PP. Referring to the record, some is that after obtaining bail, when was the first bail? On
4th,
4
February, first bail.
Okay, 4 June 2020, the accused failed to appear before the court and thereby violated the bail condition.
No, Your Lordship, the accused did not fail to appear, but then he had violated.
I'm
That-
appearing now.
Just a second, just a second. The accused has violated the condition given in the bail.
Okay, thereby
That-
he has violated the bail condition.
That was the reason for cancelling of his bail.
Okay, bail condition, due to which his bail was cancelled. Moreover, his bailor
Baylor discharge. Baylor discharge.
was also discharged on his prayer.
23 June.
Stop. She further submits that the trial is at the final stage of, the case is at the final stage of trial. Except for one, all other prosecution witnesses has already been examined, and there is a prima facie there is an incriminating material against the accused, and he is likely to be convicted for the offense, for the alleged offense. Therefore, therefore, she opposed the release of the accused at this stage. Anything else?
Yes, Your Lordship, since he did not cooperate during the entire trial, there is chance that after bail he won't be cooperating further, Your Lordship.
Okay. And since in the earlier occasion, after obtaining bail, he did not cooperate and appear before the court for trial regularly, due to which his bail was cancelled, there is every chance that he will jump bail if he released on bail, and released on bail, in which case the trial of the case will be prejudiced. Okay, then anything else?
No, Your Lordship.
Okay, so bail will be rejected. Okay,
No,
fine.
it will be very hard because
The final stage, if you're acquitted, well and good. If you're not acquitted, what's the point?
things are pending and matter is fixed on November.
Okay.
Because after this is September, October, November. Again, till November, then after 2026, I have decided that. That is the issue here. And
On hearing the
no
parties
strong
and on
reason-
perusal of the records,
There is no strong reason.
it appears
for-
that the accused, while on bail, did not cooperate and appear before the court for trial, due to which his bail was cancelled and subsequently taken on
That is actually wrong.
Custody.
Commission also. On 26,
Uh.
26 June, I along with the bailor myself voluntarily appear before the court. It was a before that it was
No, non-bailable warrant was issued.
non-bailable
Therefore,
warrant, but it was never been executed by the police.
not an execution. I did not
It's not executed.
Not execution.
When I-
Taken on, bail after cancellation, he was taken on,
Custody.
taken in custody, into custody.
May I look?
Hmm.
On 26 June, what had happened? As per the previous court order, I along with my bailor reported to the court saying that
and for trial. On that day, my bailor was not ready to.
And also considering that the trial of the case is at the last stage, and he's likely, and there is a prima facie incriminating material found against him on evidence, in view of this, I am not inclined to grant bail to the accused at this stage. Accordingly, this bail application stands rejected. Okay.
I may be allowed to oppose because matter will after 2020 the matter will be going on the political side. Because on November,
However,
on November matter.
when the next date is fixed
On
for
6th
313.
November
Not
20,
yet.
November.
No,
Matter
the
is
last
26
prosecution
November.
witness I have just
On November.
November. Your lordship will see that, your lord,
However, the trial court
I may be allowed
will
to move
expedite the trial of the case. November. Can it be preponed, the examination of the
that-
brought? Okay, notice
since
already.
the notice already.
Okay, already. Okay. Expedite the trial.
Deep, your-
Okay.
Item number 10.
You are always at liberty to move bail application. They will consider. Yes.
May I please, Your Honor?
Yes.
Your Honor, this is an application under section 483 for granting bail of the alleged accused in connection with Simple PS case number 64/2022. Under
This is
section,
this is trial is going on.
no,
Have
ma'am.
you received that? Received the record?
Yes, okay.
Okay. So, what was called for CD or the trial court record?
CD, ma'am.
Trial court record,
Case diary, lordship.
Hmm?
Case
diary.
diary, ma'am.
not case diary,
Yes, lordship.
Case diary is called for, my lord.
not the,
It not been yet charged.
not yet
lordship.
charged sheet.
No, sir.
Yes.
Trial court record, why is it the trial court record? Okay. So, when he was arrested,
My lord, I was arrested on 08/09/2025.
0809.
Yes, ma'am.
What is the allegation? Just a minute, 0809,
379, my lord.
379.
Taped, ma'am.
When it was registered?
It was registered on
Okay, before.
2012,
yes,
2022, ma'am.
Okay. What is the allegation is? So the case of 2022 was arrested recently.
Yes, ma'am.
Okay, so now how many days you have been inside?
Till today, my lord, I am for custody in 48 days, my lord. 48 days.
14
48, my lord.
for 8 days.
Yes.
Okay. Yes. What you are for?
I am for complainant.
You have objection?
Yes, I have very strong objection. You know what happened after 2022? He has stolen my vehicle. Actually, not stolen. He has run away with my vehicle. So since then, he is missing. Then I lost the FIR before the.
You ran away with the vehicle.
Yes.
So you are concerned with him or the vehicle?
No, I am concerned with him.
Him, not the vehicle.
Along with vehicle, your lord. My lord, what happened since then? We have tried to find out, but we couldn't find out. But ultimately, we
For almost about 3 years, he could not be found out.
correct, my lord.
So according to you, he should also be inside the custody for 3 years.
No, not
Then
not that. But driver who has taken away the car along with his father, the father is in the custody.
He is,
He is father of that main, the one of the co-accused.
father was also the party.
Yes,
Party means how he, what was his involvement?
actually father and their son, they are running scrap business.
No, just who took away your vehicle?
Father along with the son
Both of them at the same time.
at the same time. So evening usually they drop my car at my residence, and on the same day then I visited there because it's almost night.
Now, what
time.
about the son? What about the son?
Son is still running away.
He has not yet been
Correct.
arrested.
Not yet been arrested. Milord, what happened on
Now,
that?
what is the stage of, just a minute, what is this investigation?
Lordship, they still carry on, Lordship, because the other co-accused is still at large.
My lord, vehicle has been already recovered, my lord, and same has been.
See,
Your Honor, vehicle have been
It was
recovered
not
as
you
per
who
disclosure of the.
it was not voluntarily brought back by you.
It was.
My lord, this is not the case of tape, my lord.
Okay, then case of what?
My lord, the complainant has voluntarily give me to playing the vehicle on rental basis, my lord.
Okay,
My lord, kindly,
you paid, do you have any copy of the
my lord,
payment
kindly
of
come
the
to page number 21, my lord, NXRF, my lord.
21?
Yes, my lord.
So you are alleged to have taken away the vehicle on which date you said? This was 18/12/2022. Okay. Yes. What is this, page
My
21?
lord, this is the transaction record.
Okay, when the last payment was made?
Last payment was made on 26 July 2022, as per the record.
26 July
Yes,
2022.
yes, ma'am.
But you ran after there, you
my lord.
ran there, took away the vehicle thereafter only. 18/12/2022. See? And while you were still with the owner of the vehicle, then also it appears that you did not pay and thereafter you left with the vehicle itself.
No, my lord.
No, let the investigation be complete.
Correct, Milord.
Nothing is
Yes,
remained, my lord.
anything, what it says as per the case diary records.
Mr. Lordship, status of the case diary.
What is your submission?
Lordship, my submission is that, Lordship,
You have objection or not?
Lordship, I leave it to court, Lordship, because Lordship here, Lordship, vehicle is recovered, but Lordship, but it's not from his possession. It is just lying somewhere, Lordship, and
Not
but
somewhere, my lord. It was
Just a minute.
Lordship. And Lordship, more
Not somewhere.
not somewhere. It was recovered from the police station, my lord. The police, my lord.
no, Lordship. Actually, they have Lordship.
Somewhere means from where?
Lordship, it is.
When?
It is Lordship. As per the investigation, Lordship, on 8/8/25, active revised information along with police team, defendant he attempted to mislead the court was concerned identity, Lordship. Later, Lordship, he confessed his actual name. Moreover, Lordship, that vehicle, Lordship, they have Lordship from the Lordship some. Near.
My lord, kindly come to page number 4, man.
Lordship, it is Lordship. It's the vehicle lying somewhere, Lordship. Samaguri PS, Nagaon, Lordship.
What summary? This is PS only.
Yes, Lordship.
He is right.
Yes, Lordship. On verification, the vehicle recovered handed over on Jimmal, Lordship. But Lordship, who has Lordship that stolen property is bought before the PS, Lordship? That was not known, Lordship.
No.
It was seized by the police of Simaguri.
Okay, so it was found from which PS you said?
Lordship,
Samaguri
Samaguri PS, Lordship.
Okay, What is what the record says in that police station recovered this vehicle from where? And when?
From my possession, my lord,
Okay, when?
on 17/12/2022.
20,
2022, man.
20,
2022.
22?
Yes.
Where, do you have the record?
No, man, it was, Samaguru Police District, no, which was
The date kindly,
reflected in diary entry sheet.
when you said, when did you say?
My lord, kindly come to page number 3, my lord. Para number 5, I have
No, 2022, which date you said?
17/12/2022.
17/12/2022.
Yes, my lord.
It was, do you have the record?
My lord, I don't have a record, but it was written in
Madam Council, it appears if it is a 17, because he has lost only on 18/12/2022. If it was recovered in that police station on 17/12/2022 itself,
Lordship.
then probably this vehicle was not with him, not with the accused.
Lordship, as per this case study, Lordship, on verification, the vehicle was recovered and handed over on Jimma.
What is the statement of the accused?
Statement of accused, Lordship. It is- Lordship, as per the accused, Lordship, that he admitted that, Lordship, that he left the Itanagar with the complainant's Bolero pickup without returning it, and went ahead and reached their native place, which is Hakimura. On their way, Lordship, that his son, Lordship, which is the co-accused, and the driver of the vehicle stopped at Amoni to have lunch at the hotel. During that time, the driver left with the vehicle without informing that Rabul, that is his son, Lordship. Then on search for vehicle, later we came to know that it had been abandoned in the Salna area. The police of this Salna police post recovered the vehicle, sent it to Samaguri police station.
See your report.
Lordship, this is a statement, Lordship. Lordship may go through the.
Who is Rahmatullah? Rahmatullah is the
Rahmatullah is the, one of the co-accused,
co-accused?
Yes.
Not the present accused?
Premature.
Oh, this is present accused?
Yes. There are two accused, his son and the father and son.
When the vehicle was recovered by you?
On
Or-
on as per disclosure of.
No, 8
On 8/8 of 2025.
25.
Correct.
What is this? This will be difficult to understand because it says, para 5 of the status report. During interrogation, Mr. Ullah, Rahmatullah disclosed that the stolen vehicle was lying at Samaguri PS. On verification, the vehicle was recovered and handed over on Jimma by GD extract of the Salana police station dated 17/12/2022.
Milord, may I? Milord, 17/12/2022, he has run away with this vehicle. So
Yes.
on the same night, police has apprehended him in Samaguri police station.
Okay, it was lying with the police only.
No. With the accused, the police has collected from the alleged accused persons. Alleged accused person has not disclosed this thing. Only on 8 and
But
8/8
but the vehicle
2025.
was in that Salana police station since 17/12/2022, isn't it?
Correct.
The vehicle was not with the accused since
yes,
then,
madam.
not even a single day.
But he has run away with that vehicles. As per his disclosure statement, only vehicle has been recovered from the Samaguri police stations by the Arunachal police.
Now,
As per his disclosure statement.
now see who is the culprit here. He is culprit, but then police station, Arunachal Pradesh, who could not found from this Salana, or the Salana police station, who could not inform the Arunachal. See,
The alleged accused person supposed to inform to the either to the Chimpu police station or either to the complainant.
The police can also inform the Arunachal police. He has already forgotten.
Your Honor, in this case, what happened on 8/8, we tried to like track down through his mobile phone. Before reaching him 30 meters away from, then his father, we found it. Then as soon as we saw him, we arrested. As soon as we arrested this present accused person, then another co-accused person has run away. Since then, he is not, like, the police couldn't apprehend him.
See, on the same day. But see, here also the date, I don't know why and how it has been recorded. It says that he left on 15/12/2025 again. It should have been 22, 15/12/2025, not yet. Have you seen this statement of the, I don't know why and how they used to record?
Maybe the clerical or some mistake.
Suffer loss. And on 15/12/2025, he closed the shop. We then left Itanagar with the components, Bolero pickup.
Clerical mistake.
See,
must be lost.
then how do we decipher all this? How will we understand
That's lost.
what is his intention? And then he stated that he left, the vehicle was not taken by him. It was taken by the driver, some other person who left. And then that was recovered by the police. And thereafter they got scared and did not inform also. And it was not even for a single day with the accused.
No, Your Honor, the co-accused, his son is the driver.
No, he says that son and the another person, Rabul. Sorry,
His son is the driver, Your Honor.
not, huh?
In his bail application also, see, he has taken from me only. He did not return. Honorable Court, Session Court order, there also it's very much clearly mentioned.
So he is telling lie again. The father says that another person has taken without informing and left the vehicle at Salana area. Now see,
Your Honor, this alleged accused, present applicant has not come before this Honorable Court with clean hand. Before the court below, they have submitted that they have already informed to the vehicle has been seized by the police. Now, by this application, they are saying that they have already informed to the police.
now just a minute. Huh? See, the additional TP, there is some here also, and then some maybe clerical mistake, but then some incomplete information. So who left and from where? These probably regarding this vehicle, it will be available at Salana police station.
Okay.
You get this information.
Okay.
We'll not dispose of. I'm not rejecting now. And then if this information comes, because father has stated something else.
Okay.
This father has stated something else that somebody else has taken it away. And then that police, after finding the vehicle, must have investigated into, made some inquiry and must have collected some information.
Okay.
So gather those information and then we'll dispose of thereafter only. And in this this is also not correct,
Yes,
the
Lord.
date, okay? Because the complaint was lodged only on 18.
Hmm.
And then this was recovered on 17. And then this says that on again, prior date again.
In the night of 17, he ran away.
Mhm.
In the,
In the night itself, the vehicle was recovered by the police.
recovered by police, Assam.
No,
police.
not night,
No,
not night, no, not mentioned timing.
Your Honor,
Recovered by the Assam police. But see, if the Assam police has recovered, it was duty on the part of the Assam police to inform the Arunachal because it has the AR number. AR number, anywhere they could inform. And this police also could get, actually look out notice and then giving information to the police station in Assam also nearby. So there is a, see,
Your Honor, in addition to that, this
negligence
vehicle
on the
is a
part of
loan
the police
vehicle,
also.
so I am still paying the loan. That is my hardship, my lord.
Yes, but let us see.
The main, the driver, still run away.
They, if they say,
Last 3 years, vehicle was not with me, but I was paying all the loan amount.
you are sufferer. That is why I'm not passing any order now. And then get an updated CD and kindly instruct that it appears that the vehicle was recovered from that. And that kindly gather information if the police in that Salana police station has made some inquiry or investigation into the recovery of the case and what is the findings. So from there, they must have recorded something, statement where from it was found. Some other third person, what this accused person is alleging is also involved. Okay, gather that one and we'll pass necessary order. Okay.
So kindly, Lordship, it may be
Mr.
recorded in the order, Lordship, what necessary
yes,
instruction is needed.
Grateful.
Mr.
M. Roziman.
Lana Counsel for the petitioner. Also heard Ms. El Hage, Lana additional PP. The additional PP and Mr. Kodapa, Lana Counsel appearing on behalf of the informant staff, para. From the record, it the Lana Counsel for the additional, the Lana additional PP submits that from the record, it appears that the vehicle the alleged stolen vehicle was recovered from the Salana police station on 17/12/2022 itself from Salana area. And there is no any records of the inquiry made by the Salana police regarding the recovery of the vehicle. In view of the above, she prays for some time to so that prays for some time. She prays for granting some time to obtain necessary instruction in this regard. So the prayer is allowed. List this matter immediately after.
My lord, can it be on vacation bench, my lord? 08/10/2022.
Lordship,
Immediately
I
after.
won't be available on that date, then any other PP may be engaged.
Otherwise, my lord,
Right after vacation, it will be
Immediately
convenient.
after vacation. Okay.
Obliged, Lordship.
Grateful.
Item number 11.
May I please, my lord?
Who is this?
May I please, your lordship? May I please, your lordship?
Yes, yes.
Lordship, I am on interim, my lord, and my statement has been recorded by the concerned IO, lordship. On the earlier occasion, Lordship has called for the up-to-date case diary, my lord.
My lordship.
Yes.
Lordship, here, we have received the case study, lordship, but lordship, in the statement, lordship, of the accused, lordship, it is contradictory to the FI, lordship. Because lordship,
No, whether he was found arrested.
lordship, no, he was in bail, lordship. The interim was there, lordship.
No. Interim was there.
Yes, lordship.
Whether he was arrested.
Lordship, he was, lordship, interim was there, the statement was recorded and he was released on bail, lordship.
Released
Yeah,
released
Lordship.
on bail.
Yes, lordship, because interim
On which
protection
date?
is there,
On which
lordship.
date? When he appeared.
Initially,
per
I
the-
have
When did you appear before the police?
initially I have appeared on 8th of September, my lord, and
And then
thereafter yesterday I got a call from the IO lordship, and today morning 7 o'clock in the morning my statement was taken over phone, my lord,
Oh.
as per
Yes,
the
yes,
instructions I have, my lord.
Because here, lordship, statement, lordship, there's no date as such, lordship. And moreover, lordship, I don't know how is this statement recorded by phone, lordship.
Since
you have the record of,
since lordship my
being
statement has been
arrested.
recorded, lordship, and I have complied with the direction with the issued by this honorable court, lordship.
Lordship, here, lordship, in the statement, lordship, he, lordship, denied, lordship, that he owned, lordship, money of rupees 2.5 lakhs from the, lordship, complainant. But here, lordship, in the complainant, lordship, he's
No,
Sir,
where is the document showing his whether the IO has stated that he was arrested and subsequently bail on the strength of the interim anticipatory bail? Whether you were arrested?
Lordship,
his submission is
I
that,
do not
lordship,
have any instruction on that, my lord, because I am on
electronically he
interim,
given
lordship.
the
I have produced
statement,
the
lordship.
interim order, certified copy of the order, my lord, and thereafter my statement was taken and I was allowed to go.
It should not be done like this, lordship, because, lordship, he should appear before the IO in person, lordship, because he is interim.
He appeared earlier.
Yes, lordship.
Lordship, I have complied, my lord. I have complied with the order, lordship.
My question, only question, please don't submit.
Yeah.
Others, please answer my question only.
Yes, lordship.
Please. First answer my question, thereafter you submit. Whether you were shown arrested, you were arrested when you appear before the police?
I do not have any instructions on that, lordship. That case
That
diary
is the
will
only
speak.
question. That is the
Case
only
diary will
question.
speak, my lord. Since the up-to-date case diary is there, lordship.
No, lordship, there is nothing as such that he was appear in person, lordship. Because how this case that
No, you say, where from you are submitting that he was arrested?
because I have this morning only I have received this case.
Maybe, but
Yes,
is
sir.
there anywhere police has stated that on his appearance, on his,
No, lordship, it is.
where from you are submitting then? He was arrested.
Look, lordship, actually, lordship, I thought, lordship, it is there, lordship, but here, lordship, I have just go through, lordship, it is not there, because this afternoon only I have received this case study, lordship. Because since this morning, lordship, I've inquired that nothing.
8-9 case that 8-9.
Here, lordship, only the notice was issued, lordship.
8-9-2025.
Yes,
In
lordship.
case that just see what he has recorded, IO has recorded.
Lordship, and on the 8-9, lordship, it is recorded that he was issued notice to appear before the IO, but he was not appeared, lordship.
Whether you appeared before the police.
Yes, lordship. If that be the case, my lord, I have the train tickets.
8-9,
I
he
have
was
the
not
photograph
appeared, lordship.
captured before the
Please,
police
let him
station, my lord. I can bring on record those things, lordship.
What?
Lordship, if my learned friend is submitting that I have not appeared on 8th of September, lordship, then lordship may kindly allow me to file an additional affidavit. I'll bring on record some certain materials that I have appeared, my lord, such as the train ticket and the one photograph is there, which is captured in front of the police station, lordship.
Photo copy of?
one photocopy is there, my lord, which is captured in
What
front of the
photocopy?
police station on 8th on 8th of September when I have appeared, my lord.
Photocopy of what? What documents?
My
Photocopy
photograph,
of?
my lord, my photograph in front of the Itanagar police station.
Oh, learned counsel, how that will help?
Yes, lordship, I know, my
Go
lord,
and
but
you
what
can
I am
go and
submitting,
go
my
and
lord,
take
I
photographs
have
there, but
appeared
then
on 8th.
unless you appear before the eye of the case, even if you take 100 photographs also, how it will help?
And lordship, my statement is there, my
Whether-
lord.
My question, did you appear? And where
Yes,
is
lordship.
where is your attendance? Where is your attendance? Acknowledgement that you appear before the police or eye of the case. Where is the acknowledgement?
My lord, that acknowledgement I do not have right now.
Normally, you are supposed to know. You are supposed to know when you appear before the police or eye of the case on direction of the court. You have to go along with one small attendance that I am appearing before you on as per the direction. Kindly acknowledge. Where is that?
That is not
Acknowledgement.
there, lordship. That is, I do not have that
Then
document,
on what
lordship.
basis you are submitting?
Lordship, if that
What
is the case,
statement?
lordship, some more time may be granted, my lord. I'll appear again, my lord. My interim may,
Oh,
till
Lani
then my
counsel,
interim may be
Lani
extended,
counsel.
my lord. I'll appear again.
This technique, we hate this technique.
Lordship, interim may be vacated so that they will appear, Lordship.
It will have to be vacated only
Yes, Lordship.
and given
No, my lord,
time.
my statement is there,
kind of
lordship. Lordship may kindly consider that my statement is there in the case diary, my lord. And it is not the case that I have not complied with the order, lordship.
In
Wait,
that
wait,
case, Lordship, I am praying for the personal appearance of the IO.
And
Lordship.
lordship may
Where
kindly allow me, my lord. I'll file an additional affidavit to bring on record those things, lordship.
Which one is the statement?
Lordship, in the next page, Lordship.
First,
Yes, Lordship. And
what is
first
the name of the
Lordship.
accused?
Accused is
Rubul.
Rahul Bora.
Rubul Bora, my lord. He's from Guwahati, lordship.
Rahul Bora. Lordship, as per his statement, Lordship, that he denied that he said any amount from the Lordship.
Not concerned with the denial or
Yes, Lordship.
the acceptance.
But Lordship, in the record, Lordship, it is in the complainant, Lordship, they have furnished that, Lordship, this transaction is clearly stated that complainant has transmitted some amount to this accused, Lordship. So this contradictory statement is there. So it needs to be,
That is the concern of the
so
court at the
custody
moment,
interrogation is needed, Lordship.
at the moment, whether he has complied the direction of the court. He was directed to appear before the eye of the case within 5 days. Okay. Miss, just a minute.
MM Zaman, lordship.
Mr. MM Jaman, learning counsel for the applicant submits that the accused, in compliance of this court's direction, the accused appeared before the eye of the case and gave his statement. On 8/9, you did not give statement.
No, on 8/9, my
Okay,
statement was not recorded by the IO, lordship. Later on, it was recorded, my lord.
Okay, appear before the eye of the case. However, statement was not recorded on that day. The statement was recorded thereafter through. The statement was recorded through telephonic.
Yes, telephonic conversation. So far, the instructions I have.
Through
Yes.
telephonic conversation. Stop. Huh? Now, you do not have the information whether he was shown arrested or not.
That information I do not have, my lord.
And the further sum is that he has no information regarding, he has no information as to whether the accused on his appearance was shown arrested or not. Staff, Miss L. Hage, Lanet Edison PP, also submitted that record submitted the record of appearance of the accused is on 8 is sorry, the appearance of the accused before the IO on 8 is not on record. They were praised for allowing us some time to produce the updated CD. In view of the above, let this matter be listed after the entering vacation, on which date the Land Edison PP
My lord,
shall
16 or 17,
It's-
lordship.
updated CD, and the Land Council for the petitioner shall also bring on record the proof of his appearance before the IA.
The 22nd of, 22nd of October, lordship.
After vacation only.
Lordship.
Yes, lordship. My lord.
Item number 12 to 15.
The-
Obliged, lordship.
The interim order granted earlier shall continue till the next date of listing.
Obliged, lordship.
May please, Your Lordship.
Yes.
My lord, in item number 13, my lord, I have filed an interlocutory application, my lord. That is IA 235 of 2025.
Hmm.
My lord, here I'm praying for impleadment as a respondent in this writ petition, my lord.
Impleadment.
Impleadment, my lord. As a respondent in this private respondents in the writ petition, my lord, the
In
basic
writ petition, in writ petition 14,
in writ petition 14 of 2022, correct me.
how you are corrected?
My lord, the prayer in the writ petition is challenging of the minutes, the Department of Promotion Committee's minutes, dated 31/10/2019, on the ground that the promotions are prospective, my lord, not retrospective. Now, any order that would pass, my lord, if any order that is passed in favor of the petitioner, giving a retrospective effect as claimed, my lord, that will affect my seniority position in the gradation list, my lord. The subsequent gradation list, my
Who is respondent here?
Lordship, I'm appearing, as
No,
a
in 13?
Lordship, in
Okay, you are for
the, in the
respondent.
in the IA, Lordship, that which is, pleading,
You are for
Uh,
respondent.
respondent number 3 to 5,
Okay,
with the read petitioners. I have, no objection, Lordship.
okay. And who else is the respondent?
Others are performer respondents. We are
Pro
them,
forma. Okay,
yes,
we can allow this then.
yes, Lordship.
Okay. This is IA.
Yes.
Okay. Hard, Mr.
B Kaushik, my lord.
This is IA 235, in item 30. B Kaushik, Planning Council for the applicant. I've also heard Ms. N. Dangan. Dangan is for respondent number.
3 to 5.
Okay, who is
three-
for the
sorry.
government? Who is appearing? Yeah. Okay, Ms. Sangita for the state respondent and Ms. Nikita Dangan for respondent number 3 to 5. Stop. Para. By now, filing this application under Order 1, Rule 10 of Code of Civil Procedure 1908, the petitioners praise for their impleadment in the present in WPC number 14 AB 2022. As any order passed in the writ petition would adversely affect the interest of the applicants. Stop. Huh? The respondent has no objection in pleading the applicants as respondent party. Stop. In view of the above, this application for impleadment is allowed. Stop. Accordingly, who are these? The applicant. What are those names?
But applicants Jobombam, Donia Lolen, Oni Ezing, and Dolopura.
Just okay. Just
There are 4 applicants.
the applicant numbering 4 in number, namely Sri Jobombam. This page 3, huh? 1, 2, 3, 4. Okay. He is allowed to. He is impleaded. Allowed to be impleaded as respondent number. There would be respondent number 11. I think
11 to 14.
11, 12, and 13 and 14 respectively. Stop. Huh? With the above, this I stands disposed of. Okay. In main, huh? In 14 then.
Lordship, in the main case, on 3/9/25.
Just a minute. So in 14, we'll just record this impleadment.
Yes, Lordship.
Okay. In the in 14, huh? In view of the order passed today, in IAC 235/2025, 3, same name. Okay, 4, name with address are impleaded at respondent number 11 to 11, 12, 13, and 14 respectively. Stop. Huh?
And
The-
we may be allowed to file our counter affidavit, my lord. In the
Okay. Okay. So you have received the copy?
my lord, we have obtained a certified copy, my lord.
Okay. Copy not necessary now then?
Not necessary now, my lord.
Okay. Then since Mr. Kaushik, Land Council appearing on behalf of the newly impleaded respondent number 11 to 14, 11, 12, 13, 14 has already obtained a certified copy of the petition. Petition, and it doesn't require the copy. Okay, doesn't require the copy. Okay, obtain the copy of the petition. No formal notice need be issued. Okay. However, the respondents are allowed to file their affidavit in opposition. Okay.
My lord.
Okay.
Well,
Then-
all these cases, my lord, in fact, my lord, senior friend would also
So
agree.
then it will be fixed for admission hearing.
Admission
No,
hearing,
Lordship.
Or final
Lordship,
admitted.
may I submit, Lordship?
Yes, please.
These cases before this impleadment was filed,
Hmm.
there were 3 other IA applications filed, both by me and Mr. R. Saikia. Now, on date 3rd of September 25, matters were supposed to be was to be taken up, but it could not be taken up. On that date, this honorable court has given some order saying that on 17/9 the matter will be all the matters will be disposed of.
Okay.
But on 79, again, it could not be taken up due to paucity of time.
Hmm.
On that date, that is on 3/9, earlier date, some interim order was passed that may be continued. And we have already agreed that the matter be taken up on 28th of October.
Okay.
And the interim order passed on 3/9/25 may be continued.
Okay.
my lord, let this matter come up for admission column, my lord, because as agreed, my
Yes,
lord, it will
Lordship.
be taken up for disposal, my lord.
Yes, if possible, of course.
It's already there in order.
Yes, it's already
think-
there in the order dated
Yes,
3/9/25.
my lord.
On 17/9, no effective order was passed due to paucity of time.
Okay. Parties, all parties are duly represented by their respective councils. Staff, age prayed for by the parties. Let this matter be listed on
28 October.
Uh.
28.
2/8
2A.
for admission. Okay?
Lordship, an interim order passed on
Interim-
3/9/25.
Pass on 3/9/2025.
May be
Continue
continued.
till then. Okay.
Obliged.
Grateful, my lord. Highly obliged.
Item number 16.
Yes.
Interpretive
This will be same in 15 also, huh? 15 also. Okay.
has been filed building on.
And that IA will dispose. Huh? Okay. Yes.
The subsequent,
Which one? Item 16. Okay. What is this for?
yeah,
Okay.
is
IA is for?
bringing on record the subsequent mail order passed by, issued by the FX Customary Court, despite of the earlier mail order stayed by this honorable court.
This court has stayed
Yes.
the operation of certain order.
Yes.
And thereafter what happened?
In the earlier order, even further proceeding has been stayed. Then that order was furnished to the FX Customary Court on 16th.
You have a receipt?
No, I don't have, because they declined to declined to acknowledge the receipt. Therefore, I have sent it by speed post, and even I have written to the circle officer, being the administrative head of the.
Then after receipt, if they have violated, then there is other means.
Lordship, I have just brought this because the order was passed on 15th. 16th I have served. 17 was the next date. Therefore, I'm on 17 itself they have issued this subsequent notice. Therefore,
Notice
yes, subsequent mail order
for fixing when?
fixing 17 October.
17 October.
The date of earlier date of hearing was on 17 September. That was stayed. However, on the same day, they have conducted, because it is interim, we have not participated. Then subsequently, they have issued this again mail order.
What is the remedy then?
Your Lordship, instead of filing contempt, I am bringing this into the notice of this honorable court, because they have declined to receive the acknowledgement, give the acknowledgement in the order. Therefore, since there was only
You
one day-
ensure that this order reach them, and then you see you proceed with in accordance with law and with the available remedies.
So in the meantime, this subsequent order may be stayed there, because we have written letter to the circle officer, also being the administrative head of the circle headquarters, helping us to serve the copy formally, so that there will be no any possibility of procedural lapses.
Mr. R. Koi, Land Council for the petitioner, applicant in IA. By an order dated 15/9/2025. this court. State the further proceeding in respect of the impugned mail order dated 6/8/2025 issued by the HGB, ICR, and the mail order dated 9/8/2025 and 17/8/2025 issued by the HGB, presiding customary judge of the Apex Customary Court of Arunachal Pradesh, president of AAPGB and GVWA till disposal of the matter. By filing this application, the applicant contends that despite of the interim stay that means they did not receive the order.
It is presumably, however, personally, I went there, I have served.
They refused.
Then he received,
Receive.
yeah, he received, but however,
Where is that document?
Your Honor, that is the problem because he
Okay.
declined to give the acknowledgement in the receipt copy.
Okay.
So I personally, as a counsel, because
Okay. The Learned Counsel for the applicant submits that after obtaining certified copy of the order dated 15/9/2025.
page 6 is the
Hmm?
forwarding, page 6 is the forwarding address.
It was forwarded to the respondent number. Are they responding
No, he is the judge,
forwarded to whom?
page 6,
The
presiding.
provided to the presiding judge of the customary court, Sri Gichik Laling, the president forwarded to Sri Gichik Laling, the presiding customary judge, Apex Customary Court of Arunachal Pradesh, Upper Arunachal Pradesh, Upper Dabom, Bandardeva, on 16/9/2025. And requested not to proceed further with the proceeding of the of the mail order in person to the mail order dated 17/8/2025. Fixing the date on 17/9/2025 in view of the order passed by this honorable court. Stop. However, the state presiding judge, the president customary judge, the state presiding, the state court, just a minute. Huh? However, the presiding customary judge, Apex Customary Court of Arunachal Pradesh, has proceeded with
Page 12.
proceeded
Yes, page 12.
proceeded with the trial of the case, and on 17/9/2025, however, and again, issued third mail order, so-called notice for NYILE, NYILE, directing this is Lincoln Kambu is you.
Lincoln Gambu is my son.
Okay, directing the son of the petitioner. Is it?
Yes.
Son of the petitioner, Lincoln Kambu, to appear. He directed him to appear.
Directed
Him to appear before the said customary NYILE on 17 October 2025 in violation of the order dated 15/9/2025. Stop. Huh? By filing this application, the applicant, while bringing in notice about the so-called notice issued by the presiding customary court before this court, customary court before this court. Huh? Place for direction to stay the subsequent notice issued by the Apex Customary Court on 17/9/2025. It was this was 17, okay, 17/9/2025. And to serve the no, okay, just and no, just your prayer is to
prayer is for stay of the also prayed for direction to the circle officer because we have we can serve the
start. Okay, Farah. Upon perusal of the document annexed, it appears that just a minute. Huh? It appears that the head GB, presiding customary judge of the Apex Customary Court of Arunachal Pradesh, presiding the president of AAP, GB, and GBWA, has issued third mail order, so-called mail order, so-called for Nile and on 17/9/2025, despite of the order passed by this court on 15/9/2025, staying the whereby the further proceeding in respect of the impugned mail order dated 6/8/2025 issued by the SGB ICR and the mail order dated 9/8/2025 and 17/8/2025 issued by the head GB, presiding customary judge of the Apex Customary Court of Arunachal Pradesh, president of AAP, GB, and GBWA. Staff, in view of the above, this court found prima facie okay, this court, because we do not know, not sure whether he has received the order or not. Okay, because there is no document to show.
No document.
Okay, above, it is hereby provided that the subsequent notice dated 17/9/2025 issued by the Apex Customary Court and issued by the presiding customary judge, issued by the head GB, presiding customary judge of the Apex Customary Court of Arunachal Pradesh, president of AAP, GB, and GBWA, requiring the son of the petitioner, Lincoln Kambu, to appear before it on 17 October 2029 shall remain stayed. Stop. Considering that the earlier notice is stated to have refused, notice is stated to have refused by the said head GB, presiding customary judge, it is directed that the copy of this order along with the order dated 15/9/2025 be forwarded or be served through the circle officer where Bandar to serve to so and so, this HGB presiding customer so and so through circle officer Bandar. Circle officer Bandar or by police?
No, since this is civil,
Circle officer Bandar. Okay.
administrative.
Who after serve with? Okay. That's enough, I think. That's all. Okay. List this matter after the entering vacation. Okay.
So, in earlier matter, the matter has been listed after 4 weeks.
Yes. That. Yes.
Item number 17.
Lordship, I'm appearing on the behalf of appellant side, PR Das. Today, this matter is listed for the mediation, but both the parties are not agree for the mediation. So
Hard Ms. D. Rilo, Darren Council
this
for the appellant. Stop, huh? The para, huh? This matter was referred to by an order dated 29/7/2025, comma, this matter was referred to the mediation for settlement, for amicable settlement. This is item 17,
17.
amicable settlement. Stop, huh? However, the mediation center have submitted a report stating that the mediation failed. Stop. No mediation failed, comma, no settlement could be arrived at between the parties. Stop, huh? In view of the said report, mediation report, said report, comma, the mediation proceeding stands closed. Stop, huh? List this matter. This was to become for hearing. List this matter for hearing after 4 weeks. Okay.
Item number 18.
Same order.
Yes, same order.
Okay,
because
then
it was
here
not
name
better.
of Udeka, similar order.
My lord, so also.
When it was passed, mediation when it was sent
It was on 6.
on 6, the date will change. Earlier was okay on 6, huh? Okay, on 2/9. On 2/9 it was forwarded, huh? Okay, mediation failed, and at least for hearing.
Yes,
After
my lord,
4
for
weeks.
hearing.
Okay,
My lord, item number 20, 25, 26, and 7. Same. The
19 also.
the 19 is not mine.
25,
19 in 19, then in 18, in 19, Mr.
I'm appearing on behalf of S made. D made.
S.
D made. D made or S made.
D. Medi.
D made, yeah.
Okay,
And
Mr.
it may
Partin,
fix on-
Mr. Partin appearing on behalf of Mr. Partin appear on behalf of Mr. D. Medi, huh? So, and then all the same.
It may be fixed on 24th, my lord,
Okay,
because they're out of station.
then in the last, mediation fail, as prayed for, comma, list this matter on
24th October.
24 October for hearing.
Yes, my lord.
Okay,
Much obliged.
and then 20 also same.
20 also. same,
In
my lord.
20, no, just a minute. Your 19, where is 19? 19, let us see the date when it was forwarded for mediation. In 19, it was forwarded on 5/8. Okay, that only will change. And then date fix this would be fixed on 24th. Okay. And then in 20,
20 also same order, my lord.
okay, let us see when it was forwarded. 20, Mr. Udeka. Okay, Udeka. And then it was forwarded on 5/9. Okay. This is also hearing after 4 weeks. 20. 21. 21 also same, I think. This is all for special mediation. Right? Okay. 21 also same.
Yes, Lordship, a similar situated case has been disposed of yesterday, Lordship, arising out of same FIR. Same matter has been disposed of yesterday, Lordship, arising out of same FIR. That is criminal petition number 225.
What is this? This is. This was also forwarded.
Yes, Lordship.
Mhm. Same FIR.
Yes, two matters were forwarded for the mediation, Lordship.
Yesterday,
And one 225 of 23 were disposed of yesterday. only. But this,
yesterday,
yes,
do you have the copy?
yes, Lordship, I have.
This court pass order.
Similar situated matter, Lordship, arising out of same FIR.
Because this normally, what was the offense involved? See,
448, 323, 341.
okay, so
Lordship,
this cannot be actually settled through mediation. So that is why I had to justify this. I had to modify a little bit. I was repeatedly asking because how this mistakenly, probably inadvertently, they have placed it before for mediation, whereas it's not possible. And then this will go like the, where is the PS case number you have mentioned?
PS case number 38 of 23.
30 year.
38 of
also same.
2022.
Hmm?
GR 685 of 2022.
This also 685.
Yes, 685 of 2020.
48, 323. Okay, here. Okay, this is the case where later on they have agreed or what?
Yes. They have appeared before the mediation and they have agreed.
And then thereafter, okay,
Yes.
there. So the state is otherwise not the party in
Yes,
the
Lordship,
mediation.
that is not-
So that's why I have justified it. Also that state is not able, because this is later on thereafter.
Yes.
After sending before the mediation is in between the parties without excluding the state. But in the mediation, during the course of the mediation, you are for the respondent.
Yes, yes, Your Honor.
No objection.
No objection, Your Honor.
Okay. So you
Your
are the
Honor-
same counsel who appeared yesterday also.
Yes,
Yes.
yes, Your Honor.
Okay. Then this will go.
But Your Honor, may I please, before the mediation, the petitioner was absent actually, na?
Hmm?
Your Honor. Before the mediation, petitioner was absent. So, settlement between the parties actually could not be done. It was done, but the other settlement could be done with other parties.
Other accused part, other person.
accused, that is.
Not with the
Techi
present one.
Gomin.
Not with the present one.
Yes, not with the present one, because he was absent.
So you have objection to the present one.
Your Honor, next time may be given for the report of settlement. Your Honor, settlement
have-
agreement has to be executed outside the court, Your Honor.
If I may, Your Honor, Lordship, Your Lordship, since the one who has already settled and this honorable court has passed
No,
disposal order yesterday, he is the main accused
yesterday
person.
whether you have submitted the agreement copy,
Lordship,
agreement copy,
no, Lordship,
or no agreement copy.
no, Lordship.
But then it was only mutually settled only.
Yes,
Yes.
before the
Okay.
mediation board.
Now, so you have an objection.
Yes, Your Honor.
Now it will be difficult for you.
Lordship, since the matter which was disposed yesterday,
No, now
he is the
yesterday
main
it was
accused.
disposed
Lordship.
because he agreed.
That is, I leave up to the
Now-
Lordship discussion.
Your Honor, because
Otherwise, Lordship, this.
for yesterday
can be covered
matter,
by yesterday.
Now if he
appellant-
objects means he
petitioner
will
was
file
there, no?
objection. Yes.
petitioner was there and
Now
settlement.
what we'll do,
Has
just
done.
you negotiate with this present also. Present also negotiate with the respondent, and then come again when both party agree, then we'll pass similar order. Okay.
Yes,
What I
yes,
am submitting
Right.
for your lordship is that only that would be the futile exercise for this honorable court and
That is so,
the
but then
respondent.
since he has
Otherwise, this
objection, we
matter
cannot
is
force him.
entirely covered up by the.
Since you have agreed with the other party, you agree with me also. We can't say that. Okay.
If,
uh,
they are ready to
okay,
go.
then similar order.
Yes.
Okay, here, the mediation fail, huh? Similar. Then here, appearance of Mr. Ingo, no, will be recorded. And additional PP, Mr. Miss L. Hage, and Mr.
Till Omdak
Okay,
appearing
also
on behalf of.
present.
uh,
No, like yesterday,
Yes.
or not yesterday. It's similar order. Who has taken the order? It's similar order only with with this item 17, 18, 19, 20. Okay, only the party will change. Three, now all of them, and then same order. This was forwarded on.
On
by
20,
another date, forwarded
1,
on
8,
1/8/2025. Okay, similar order. So this, we'll keep it.
yes, lordship in this interim is there. Interim may be called.
Hmm?
Interim is there.
Okay. Then in the last, at least this matter after 4 weeks, the interim order pass earlier shall continue till the next date of listing. Okay.
Deeply honored.
obliged.
Item number 21.
Item?
Item number 22.
Yes. Yes.
My lord, here, my lord, we have yet to obtain instruction from the respondent, my lord. So the mediation may be kept open since there was a chance of settling the matter outside the court.
No, it has already referred back. As and when the party agree, then we'll refer it again because it has been referred back here before the court. The matter referred back. Then why you have to send it back?
No, not send it back, my lord. We have yet to obtain the instruction, my lord, because it was fixed for mediation, but the respondent, my lord, we couldn't obtain any instruction yet.
Matter has not been settled through mediation. The matter refer back to the court. So, as and when the party agree, you are for?
And for respondent number 1, I have been instructed by Koda Tamo, my lord, the concern for respondent.
But then since it has been referred back, we'll place it before the court again. And then as and when the party are in, but on that day, both the parties were present, it appears.
Yes, my lord.
Hmm. So what do we do?
My lord, next date may be given. By that time, we may they may take instruction from both the parties.
But earlier also it appears they agreed.
Yes, my lord. After that, there was no further instruction.
Okay. So agent, when the party appear, we'll send it back again. Okay. Same similar order. Here. You are Miss
H. Jeram.
no, Jarang is appearing on your name is not there.
Yes, my lord. So
Okay, Jarang appearing on appear on behalf of Mr.
K. Tama,
Tama, Learning Council for the
respondent.
respondent.
Respondent number 1.
Okay. None appears on behalf of the appellant. That similar order. This matter was this matter was referred to mediation for amicable settlement
by an order dated 1/8/2025. Okay, and list this matter after 4 weeks. Okay. Similar order. Yes.
Item number 23.
No. This is 22. Huh?
22.
22. Stama is there in 22. You are in 23, I think.
23 and 24.
Oh, 23 and 24. Okay. No. This is in 22 only. In 22 you are not there.
I'm sorry, my lord, I'm in 23 and 24.
Tama is in 23.
Name same, my lord. No, in 22 also, my lord.
Oh, Dorji Net Pro.
So I got 22,
Then, okay, 22, 23, 24, 22, 23,
24.
22, 23, 24 also. Okay. In 22, who is appearing? 23 is Dorji Letro. 23 is also Dorji Letro.
This is the reason I got confused with the name.
Now you tell me you are in 20.
23 and 24, my lord.
And then who is appearing on 22? 23 also same party. Okay, Singa. Okay. So this without that the earlier order would be in 22, 23. Jerang appearing on behalf of Tama correspondent. And then at 22 also similar order by an order dated 1/8/2025. This matter was referred to mediation for amicable settlement. Okay. List after 4 weeks. Okay. 23, 24, Ms. Jera. And 25 now.
Item number 25.
55, my lord. I'm very member.
Okay.
So it
Twen-
was not materialized.
Okay, 25 also similar order. 25, the order was passed on by an order dated 6/8/2025. And at least after 4 weeks. And 26,
26, 7 also. My lord.
then in 25, Mr. U Deka for respondent. Okay. You are for?
I'm for the appellant, then in 26 for appellant and 27 for respondent.
In 27 or 27? Where is 27? Was referred to mediation on 10/9. It was referred on 10/9/2025. Okay, you are appearing for in 26. You are appearing
Here
for.
I am appellant, my lord.
You are for 27.
27, I am appellant.
Oh no. Okay, 26 was
26, I am respondent.
okay. Have we passed order in 26? Have you given me? Kindly see the date of reference. Okay, in 26 it is on 6/8, and in 27 it was referred to mediation for amicable settlement on 10/9. No, not 10/9. Where is the referral order?
It should be on 6 September, my lord.
Yes, it's 6. Why it has been written 6, 8? Hmm?
Because mediation was held on 6 September onward.
There is some difficulty, I think. The order. Counsel for the party, let this matter be referred to mediation for settlement for mediation. It was, but thereafter, why this order, subsequent order has been passed on 10/9/2025? There is some difficulties, it appears. It is 27. I think this is wrongly, I think. Just see one similar order. It was forwarded on 6/8. Huh? Just see once. This probably is order, should have been order in some other case. Name of the advocate also different, date also different, and this is the order referring. Okay, just see this. This is not in this case probably because advocate also different, admit. This cannot be. This is supposed to be in some other case. Maybe some mistake. Just see it. Similar order 27. Udeka 6/8. Yes. This also will be placed after 4 weeks.
After 4 weeks.
Okay.
Item number 28.
This is for hearing.
Yes. Oh, yes.
We have only 15 minutes.
No, my lord, on last occasion, it was not informed that the appellant, my lord, the jail term has been over.
No, your honor, he has been convicted for the 3 years. And he has already spent the 2 years in the jail. But the jail authority of the Teju, he informed me that on 27/5/2024, 1 year back, the Assam police has transit remand before the Lakhanpur police.
Assam
Lakhanpur
police?
has transit remand because he is arrested another case, your honor. This accused appellant.
Assam police has
Produced before the
asking for transit remand.
Yes. For Lakhanpur, and the Lakhanpur court has enlarged him on bail. And he's on bail and he never, and the police was never arrested. So
Who was never arrested?
the police, the Arunachal police,
Arunachal police.
yes, because he is in convicted in in languishing in Teju jail, your honor. And he was arrested in another
No,
case.
Police, Arunachal police is supposed to arrest him for what? Which offense or in what?
POCSO, where he was convicted, your honor.
How he can be convicted without arrest?
Okay. Your honor, he was arrested, he was convicted in the POCSO case. And the sentencing of his arrest was 12/9/2000.
Sentencing?
Yes. My lord,
Sentence
to
for-
page 63, my lord. 63 and 64.
6-3.
Yes, ma'am.
63 and 64 lawsuit. 64 is the more appropriate lawsuit, where they conviction year and
Oh.
date it also.
See, I think you need to come prepare with.
My lord, actually what happened, his conviction period was over on 12 September 2025, my lord. So this now court is instructed that whether the person is in the jail
That's-
or not.
That's not a concern of the court. It's a concern of the jail authority. If he has already undergone all those, then it's a duty of the jail authority to release.
Yes, so my lord, what happened, according to her, my lord, she is submitting that he has not yet completed the tenure of 3 years. He had to complete it 3 years, but he stayed only for the 2 years, and he was called for some other case, and for that he had to go, and he in that other case he procured bail, and after that he never returned back to the jail. This is her suggestion, my lord.
An NBW was issued, Your Honor, by Session Court Pasigat, and it was executed before the Session Court Pasigat date. The next date is fixed on 24 October 2025, Your Honor. Still, he was not completed his conviction, Your Honor. Still, he was not
Appeal will go on.
because he's already spent 2 years in custody.
Now, these matter, if there is a problem in it, probably the matter is to be reported. And then the jail authority has to report it.
That's
And then why the jail authority had to release him? If at all he was required to be produced in some other, it was to be actually in with escort only. But they will have to face now, if there is any difficulties in this regard, apprise it before the appropriate forum, appropriate court, appropriate authority with appropriate application. This court, without those information, cannot pass any order.
Lawsuit,
On-
then
Why-
I'll call for the instruction lawsuit from the jail authority.
Mhm.
Unless you-
From the state lawsuit, I'll call for the instruction from the jail authority regarding the situation of that lawsuit, present conviction lawsuit. Because lawsuit, as per his statement lawsuit, that accused is no longer inside the jail. So whether this appeal will continue or not, lawsuit, what the instruction of the jail authority lawsuit, what step they have taken till now, lawsuit.
unless if he is brought into custody, my lord, the report from the jail authority, this matter may be keep on abeyance, Your Honor.
Miss O. Binger, learned amicus curiae. Apprised before this court that in the instant case, the convict, what is his name?
Sukur Ali.
Sukur Ali. On what basis? But I think you just have to collect the information from jail authority and file small application. On that application will pass order. Okay. Because where did you get this information?
Yesterday, Your Honor. Yesterday.
Because you have
From
to submit by giving date.
I spoke to him.
On which date he was released? On which date he was released? On
Was released on
by in compliance of which order?
27/5.
Yes, yes, you have those information. File a small application. Will direct. Okay. On the prayer of the learned counsel for the party. Okay. Miss O. Binger, learned amicus. Thomas. If amicus for the appellant. Miss L. Hage, learned additional PP. And Miss H. Jera, legal aid counsel for the respondent stroke victim. The respondent number 2 victim are present. Stop. Miss O Binga, Planet America submits that she has an information that the convict, Sukur Ali, is no longer inside the jail. She has also an information that he was released from the jail. Now, this information you have to give properly. Okay. You have to file because unless you show some document, proper information, it will be difficult to pass. Okay. Ms. Binga Planet America Sami said there has been some subsequent development in the case, and therefore pray for some time to file appropriate application in this appropriate application. Prayer allowed. List is matter after the entering puja vacation. Okay. You come with the proper information. Okay.
Item number 30.
Yes.
My lord, it has been corrected, my lord, chronologically. As per my lord, annexure.
IA is for what?
This is for my interim order. Interim order.
Interim order in what?
My lord,
Suspension of sentence.
section charge.
Suspension of sentence.
No, this is not the sentence, my lord. This is a judgment and order passed on 28 July 2025, my lord. My lord, originally the case arises from the Chief Judicial Magistrate 0, my lord. And Learned Chief Judicial Magistrate has acquitted the accused person, my lord, by the order, my lord, 0105.
Any order passed in that
My lord.
appeal? Have we passed any order in the appeal?
Lordship, Lordship, appeal.
Appeal was filed by the informant, my lord. The respondent.
Informant? Okay.
Opposite party number 2, my lord.
Appeal was not filed by
Accused. In the original case, my lord, I am the accused person, my lord.
you are co-accused.
Yes. So in the court below, the Chief Judicial Magistrate Chief Judicial Magistrate 0
No,
has
no.
acquitted.
This appeal has been filed by whom?
This is filed by the my lord, accused person.
Okay. So this I was asking about this.
So according to my lord, the appeal has been admitted by this honorable court. So in view of that, my lord, my prayer is only for the interim order. Till the final disposal of the
Challenge the judgment.
appeal.
So, my lord, on 22, my lord, appeal was filed. And on being filed, my lord, this our court was pleased to admit the appeal, my lord. Annexure C, my lord, and page 50 of this IA, my lord. So,
What is this IA 94, 5 is 94? IA 95? What is this IA 95 for?
my lord, this is the order passed by the this honorable court, my lord, by
No, no, 95
withdrawing that IA
95 is
because of
something.
the certain
95
discrepancies.
Nothing to do. Okay. So this is application for. You said that it was initial. He was acquitted
Yes, my lord,
by
by the
CJM,
CGM.
but he has been convicted by the
Session judge,
Session judge.
session judge, 0. On the basis of appeal filed by the informant.
informant. Now he is on bail.
Well, he is free, well, he is not, because as on today, there is no any execution order
Hmm?
in connection with the minor, the
Okay, there is also no order for execution of the conviction.
minor. He is convicted, but not a formal order.
In IA. Had Mr. T. San done a counsel for the applicant. Also had Ms. L. Hage done an additional PP for the state. And then probably there also notice is to be. We have included the respondent number 2 also.
Yes, my lord. We have already taken the step, my lord.
Para. The appellant and the petitioner filed appeal. Under section 415 of the BNSS, 2023, challenging the judgment and order dated. Is it a judgment or judgment and order dated
27 or 28, 7.
7/2025, passed by the Learned Court of District and Sessions Judge 0 in criminal appeal number 02/2024 within bracket Z bracket close. Corresponding to GR number 13/2020 arising out of 0 PS case number 5/2020. Whereby the applicant has been convicted and sentenced to undergo rigorous imprisonment for 1 year, along with a fine of rupees 10,000, and in default of payment of fine, to undergo further simple imprisonment for a period of 3 months for offense under section 325 IPC. Stop. by this application, the applicant Paraha prays for stay stroke suspension of the judgment and order dated 28/7/2025. It's all the same only. Passed by the learned district and session judge. Zero in appeal criminal number 2/2024 within bracket Z. It is submitted that the convict is on bail, still on bail, and has not violated any bail conditions. Stop. It is further submitted that since the appeal has already been admitted for hearing, the applicant stroke appellant may be allowed to remain on earlier bail, on previous bail, on same terms and conditions. Stop. Tara. Ms. L. Hage, Lanet, additional PP. No objection.
No, sir.
Submits that since the appeal has already been admitted and the accused has there is no any indication of accused having violated the bail earlier bail condition. She has no objection. Granting, allowing accused to remain on earlier bail. Stop. In view of the above and considering that the appeal has already been admitted for hearing and the accused has not violated the earlier bail condition. And there is no indication of accused having violated the earlier bail condition, the prayer of the accused applicant is allowed. Stop. Accordingly, the convict is allowed to remain on earlier bail on the same terms and conditions. Stop. On the subject to the condition that the accused deposit the fine amount before the trial court. There is a fine of 10,000. You deposit fine amount?
10.
Fine amount of rupees 10,000 before the trial court within 2 weeks.
3 weeks.
3 weeks. It's a session court.
Session.
Then I think session court is out of station for some days. So we'll give 30 days.
Oh, my.
Okay, 30 days. With the above, this
I hear it.
I will dispose of.
I stands disposal. Okay.
Much obliged.
Then list again, Lordship, matter.
Hmm?
The matter will list again Appeal.
Appeal, I
Already
think
fixed.
already there is a
It is
direction.
already fixed, my lord.
There is a direction. IA, whether in the IA probably this can be disposed of.
I only IA will dispose of loss
Yes, yes.
because
No,
appeal will
appeal cannot-
continue.
appeal
loss.
cannot.
Ah,
It's after it will be listed after 4 weeks.
Yes, losses.
Okay.
Much of. Item number 31.
We're filing IA.
You have made state also party.
Yes, my lord. The deputy commissioner.
IA is for what?
IA is for condonation of delay. my
Okay. Okay.
lord. Notice may be issued.
Okay. Mr. Mokmong Party, Land Council for the applicant. Sarah, this is an application filed under section 5 of the 5 of the Limitation Act 1963 for condonation of delay of 10 years. I thought it's 10 days.
My lord, we'll have to get into the facts, my lord, otherwise, my lord. Whatever objection they have, they can come on the next
Okay. 10 years.
after, my lord.
I think this is the,
I have a small submission to make, because as the DC were have in that time, because they are challenging in TRP, they are challenging the disease order from 2015.
Huh.
Then at that point of time, Lordship, DC was adjudicating the case as a judicial officer.
My lord, I have,
He ought not to have been made a party.
my lord, I have multiple.
so you have made DC as a party?
Yes,
No, this is not a party.
party in the IA.
This is the
IA.
party, my lord.
Huh?
This is the party, my lord.
Head Gambura.
This
Party
is the party.
As a
Head
response
Gambura.
number 1.
Hmm?
Party as a response number 1.
Oh, Arunachal Pradesh represented through the deputy commissioner.
Which? Lordship, I'm talking about IA, Lordship.
IA,
Yes.
the state of Arunachal Pradesh represented. State is represented by deputy commissioner.
Wrong copy, Milash.
I have been served, it seems I have been served the wrong copy. It is not written. State is not represented by DC, Your Lordship. CS, Chief Secretary.
Hmm. The state can.
This is the DC only, my lord.
No.
We have made DC a party.
No, what is the impugn order?
The impugn order is, my lord, it's in,
CRP. Government land, Your Lordship.
It's not a government land.
It is
Government is not a
between
party to
two
the
private
dispute.
land.
no, because this is a civil revision petition we're challenging. We're not challenging, but we're asking for modification in the impugn
Then you
order.
file review.
This is a revision petition, my lord. It's a revision petition, that's why you
No,
filed.
you said
It's
that it's for modification. Modification only the review petition can lie. If there is if there is a error apparent. And if you have pointed out the error apparent for modification, you can file before the deputy commissioner. There you file condonation petition also.
There is no, my lord, there is no deputy commissioner does not sit as.
Then they'll forward to the, because now the situation has changed.
Yes.
Authority has changed.
Yes.
Now you file there and then they'll refer it to the appropriate authority.
Which will be, my lord?
No, you file before the deputy commissioner.
No.
Because the deputy commissioner refer, because all the cases, deputy commissioner has to forward it to the court, judicial court. Now they will say that who is the right authority now?
No, my
You
lord,
guys for the notification.
my lord, the
interpret.
facts, I'll have to explain the facts, my lord. What has happened is, my
I
lord,
think we are running out of time. It will be
my lord,
difficult.
that's why I'm saying whatever objection they have, let them come in the after the issue of notice. my
No,
lord.
the notice
Support
cannot.
Your Worship, yes.
Because
Knowing that this is
Because
has acted as a judge.
the
how
facts
do we-
is, my lord, the facts are extremely relevant. Otherwise, we cannot understand the intricacies of the case, my lord. We'll have to explain. I'll have to explain the case. I'll have to
No,
go
no,
through
no.
the facts.
DC cannot be a
We
fact.
cannot spend the night.
My lord, I'll just
You
take
explain,
15 minutes, my lord. 15
I'll
minutes, my
give
lord.
you, I'll give you 3 hours.
Take 15
I'll
minutes,
give you 3 hours after vacation.
my lord.
Hmm.
My lord, I'll take 3 minutes. 15 minutes, my
No,
lord.
no,
I'll take
no,
that.
no, no. Idiot.
My lord, because the facts
Because
are.
now I think you have to make a small research on it. And because
My lord, I have
error was
case
filed
laws, my
by-
lord. I can clear case
No,
laws.
notice cannot be now. Because the deputy commissioner acted as a judge. Supposing today
Then, my lord,
the
my
district judge passes order, can you implead the district judge? You have to implead the private party only. To whom there was a contest, against whom there was a contest before the court, not the judge.
my lord, because DC will have to be the one making the changes,
No.
my lord. DC
That
will
is
be
why you
the-
file before the deputy commissioner. And then the present DC will say,
My lord, how do we file
no,
before the
because
DC?
see, the notification, state government notification, if the DC is not available, who is the next authority is there in the law and in the rules. So accordingly, the DC, all the cases after this notification of the government notification, it was forwarded before the trial judicial office, a judicial court, and it will be forwarded. Let them forward. Let them deal with. Because who has replaced the deputy commissioner now? It will go to him only. It will go to the person who has replaced the authority of the deputy commissioner. Who is having the deputy commissioner power now?
Civil court.
Deputy commissioner then power of the deputy commissioner is with the district judge or chief judicial magistrate, if it is a civil.
My lord, because this was a dispute between two villages, my lord.
That is why I'm saying.
And the DC
You have to
formed
file
a
against
committee, my lord. The DC deputy commissioner formed a committee, and DC and between two territorial dispute between two villages. And what happened is that DC formed a committee, and thereafter, what happened in light of the results of this
Okay,
committee?
DC formed a committee.
Yes, and that took time. This matter was listed before the DC in 2005 and 2015. On the basis of the report of the committee, this judgment was given, my lord. We have to go to judgment. Without it, my lord, the DC is the relevant party, my lord. DC is the relevant party without which.
Now, once we issue notice,
Yes,
it
my lord.
cannot be recalled back again. The notice will go. Then the DC will DC. If the DC is not the necessary party,
My
how
lord,
will he
based
respond?
on, because my lord, what is happening is two villages had a territorial dispute. Now the DC
Now, I
formed a
think,
committee.
so these few days will not make much difference. There's
Because
a 10 years, delay of
We have
10
to
years.
wait it.
My lord,
So we'll have enough time. And then you also come with little more research into it and who is the right authority at the moment. Because earlier it was DC, now DC is no longer in the authority. Now DC has decided this in the capacity of judge only. Now who has replaced the deputy commissioner? Who has taken the power of the deputy commissioner at the moment? So list it after the vacation. Okay.
so 22nd, my lord.
Okay, on 22nd. Okay. Okay, 8th grade. 4, this matter on 22nd. Okay. Item number 32. Okay, none appears on behalf of the part. Oh, yes,
Yes, my lord.
yes. So these, why it has been listed? Okay, this was fixed. We'll
Before
fix it
hearing, my lord.
after. Okay, Mr. Empart, Magbompart, Learned Counsel for the appellant is present. Due to paucity of time, the matter could not be, okay, none appears on behalf of the respondent.
Respondent, yes, my lord. No one
Okay.
appeared.
Okay, in absence of the learned counsel on behalf of the, in absence of the respondent, this matter stand adjourned, list this matter after the ensuing vacation, puja vacation. Okay,
Much obliged. My lord, this also fix it, my lord, please, 24.
24.
Yes, my lord, this has been
Okay,
pending
as per the
on.
Rama, list this matter on 24.
Much obliged, my lord.
I think it was a full day before vacation.